Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020, 7:44 p.m. How, period, does the FBI find people? The people is misspelled P-E-O-O-P-L-E.
I object.
Did the defendant find out how the FBI finds people in this case? Oh, she found out.
Because he's the guy! What more do you need to see?
Good morning, good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Happy, it's almost Monday afternoon. I know I'm a little late. It was a long weekend. Oh, man. Good morning, good to have you all here. Let's see. Let's get everything put together here. That not working? That's not right. Let's see. It's definitely a Monday. I don't know what happened. My desk shrunk over the weekend, and I now have no room. Like things that used to fit, I've got like a remote over here that I need, but I don't have space for. Like that goes somewhere, but I don't know where. Not there. Oh, that's broken now. Wow. Stay. We'll hide that. Nope. Doesn't fit. Doesn't fit anywhere. Does not fit anywhere. Let's put this over here. This right here, maybe. Stay. I need to figure out what's wrong with this. I'm trying to show you who. Upstream keyer.
This is not Burger King. People do not get to have it their way.
Oh, did I change my upstream keyer? Hang on one second. Upstream keyer 4. I was helping Ada K the other day, and I changed some settings on my. Let's see, chat 5, mask. It works there. Means it's over here. All right, hold tight. Good morning. As we get started, I was hoping to watch some Judge Simpson this morning, but he's gone into incognito mode. He's flying under the radar. I'll get to welcome 80s Music Man first in chat today. Congratulations, 80s Music Man. You've done this before, so you know the drill. You are now responsible for everything internet-related worldwide. And, yeah, enjoy. Please take care. Please fix it so I don't have to. I think that's going to be my plea for the day. It has been a wild weekend with this storm and everything else that's going on in eastern North Carolina, or western North Carolina. I am eastern North Carolina. Western North Carolina got hammered. Like, entire small towns just wiped off the map. Last I saw, there were 40 deaths in North Carolina, 40 confirmed deaths and 600 missing. It's hard to even wrap your head around what happened there. And it wasn't that this was like, I heard somebody describe it as, this was like a 100-year type flood. No, this was like building a house up on the mountain, and they compared it to Noah, to Noah's flood, which is sort of funny, but at the same time, it's not. This has never happened. It's never. You don't expect when you build a house up in the mountains to get flooded out, but. Okay, let's see. IP address 4.29. Just one second, I'm going to Make sure I'm all set up right. Network, Wi-Fi, details. Four 4.21. This goes to 4.21. It should be working. That's crazy. Disable, enable. Why would that not work? All right, I've got a couple things to do here as we get started. We might go down to Chancery docket with Judge Wolf. We've got a couple things. Thank you, Josh, for that link, by the way. Let's see. Green-Eyed Cat, congratulations. Gifted 1 membership. Thank you very much. Chris Wallace, member for 15 months. Good morning. Britt Bottoms, member for 8 months. A member of the jury, by the way. Time flies when you're having fun. Love hanging out with you guys. Nina Nana Linda, member for 20 months. Prayers for the NC National Guard who are responding to the cleanup, including my son. So proud. Nina, that is awesome. That is awesome. They need every bit of help they can get right now. Kelly says, best place to be. I live 1 county over from Unicoi County, Tennessee. Oh my goodness, Unicoi was destroyed. Our highway going into Asheville, part of it is gone. Okay, you are right there. You understand the severity of what happened. Tennessee got slammed as well. Absolutely crazy. Once again, all right, took his own advice, starting before he's ready. Yes, I sure did. Let's see, we have some birthdays to sing to. Kelly says, donated yesterday during the NASCAR race to Red Cross. Thank you. The crazy thing, Crisis Cleanup, the group that I normally help with taking phone calls, and I've been trying to do this all weekend. I've been working with them. Their system is slammed. There's one guy who does the programming, and he does it for free. And yesterday they took more calls than they've ever taken in any incident. Over 9,000 calls for help, for mucking out, for trees down. People need help getting out of their driveway or blocked in their house or their house under a tree, all sorts of stuff. Took calls for all those, and that's before, really communication services have been restored to a lot of these areas. So they're expecting it to be absolutely just massive today. And in all those problems, one of the problems they're having is that a Mac will not work with their system right now. And I have 4 Macs and nothing else. So we'll figure it out. Anyway, let's see. Let's get birthdays ready. I am so tired. I shouldn't be this tired. I just feel like I'm spent. But let's go. All right. Let's see. Queen Olive, Lynn, Ruby, Mark, Anna, Florida Sun Life, all having their birthdays today. We're going to celebrate with them. Warm up with me if you will. La 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 la. That was really bad. La 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 la. That was better. Okay. All right. Sing with me. Blend your voice with those of your neighbors. Deep breath. Dancers at the ready. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, Queen Olive, Lynn, Ruby, Mark, Anna, and Florida Sun Life. Happy birthday to you. Queen Olive, Lynn, Ruby, 5. Mark, Anna, Florida Sun Life. Happy birthday. It's all of you get to share this special day. And it is a special day. It's a day to go get free pancakes at Denny's and Waffle House and IHOP and Village Inn and everything else. Do that, and then that will start your day beautifully. Other than that, hopefully we can make your day a little bit better as we hang out and party together. Just enjoy the greatness that is a Monday, as we have the whole week before us, and anything can happen. Anything can happen, as we saw from last week. Judge Wolf here. We might be jumping to Judge Wolf. Where did Heavenly Wood go? I've seen all these other courts, but not his. Is he not live yet? Loving these drums. I don't know how long this verse goes. Was that our drum solo? I think we've got more time. We've got more time. Hang on. I don't know when the drum solo comes in. That was it. That was it right there. There was no prep, but my brain is just not firing on both cylinders today. All right, let's see. It's devastating. Finally heard from my cousin last night. I was so worried. Oh, let's see. It's crazy. So many people. The communication is one of the biggest things. First of all, it's not knowing, right? That is just so terrible. And there's a lot of not knowing right now. It's amazing. I saw Ryan Hall posted some of his crew as they were taking donations to help the hardest hit areas. They thought they were going to be down in Florida. And it looks like Florida did get hit very hard, but there's a huge need in North Carolina, Tennessee, Georgia, South Carolina. There's that whole area just got devastated, and communication is extremely difficult. So he went out and bought all the Starlink mobile units he could buy in West Virginia, and was trucking them down there to give out to government agencies to set up as public hotspots so people can text and things like that. Just 2 cylinders. Hey, that's twice what I have right now. Two is better than 1. When does Sarah Boone start? Soon, Chris. Soon. Oh my goodness. I saw part of this hearing, Jen, about a couple lawyers complaining about Judge Boyd running her live stream, complaining about her taking calls from her mom. Butt hurt much? Is it too soon to say that? I think they probably got raked over the coals for something, and now they're just trying to strike back. And I would just suggest to them that they not practice in Judge Boyd's courtroom next, because she's not going to go easy on them. Barb Russell, first timer here. Welcome. I'm sorry, today's the first time. Brandy's going to Boone in person. Yes, she texted me about that. That is so exciting. I've got some good people going down there. I think Peter Tragos is going to be there as well. We've got Trial TV Live. Jules is going to be there. Lots of good people. A green courthouse to go with my cat. Thanks for the fun 2 months. Y'all are the best. Thank you very much. Yeah, a little sour grapes on the people that are dissing Judge Boyd, and their whole spin on she tells you have to stand in front of the camera, you can't turn your back to the camera, and she says it's because then the court reporter can't hear you, but she can. I'm like, seriously. RA, have you gotten any of those? Yes, no zeros. Thank you. She denied the delay due to FMLA. One of the lawyer's daughter was born. Oh, that might be an issue. But okay, let's see if we can get this one pulled up here. Let's go to the MacBook Air. Let's try that. All right. I think, Josh, if I'm not mistaken, we've got a follow-up on a case, the DNA case. So let's see if we can follow up with Judge Wolf. Give me just 1 second. Shrink this down. Why is that not working? All right. It's 9:23. Do you guys want to see it? So I'll put it over here on this other screen for you. Give me a second. It's going to be at 2:39:34. All right. Are you guys seeing this? Are you hearing this? I'm not hearing it yet. Now we are.
Approving the sale and reserving all other matters pending another hearing or our agreement.
Thank
Your
you.
permission. All right, thank you, sir.
Kelly, thanks for gifting a membership.
2022 CV 318, Michael Andrew Betts versus Janie Eudora Myatt et al.
Et al. Et al.
And I assume this is also going to involve the estate of Richard Omar Myatt.
Yes, Your Honor.
We've been following this case for a while. This is a disputed inheritance case that involved DNA tests.
We have a motion to distribute undisputed funds, a motion to allow expert testimony via audiovisual transmission. Those are both filed in the Betts versus Myatt. Then we have in the estate of Richard Myatt, a motion that heirs and other interested parties be served pleadings, a motion for a scheduling order, a motion to allow expert testimony via audiovisual transmission, and a motion to continue. So whose motion to continue is it?
Judge, that is our motion to continue on behalf of Sam Myatt.
You can't do the continue and the other things today.
Judge, a little bit of past history, back history. We were in court on August the 1st.
I remember the case, but I want you to go ahead and state your history of the case.
Well, just
I
that
forgot something.
Just that we were last in court, Judge. We were last in court on August the 1st. The court continued the matter to allow my office to get in contact with EDC, and for that reason, it was reset until today. Judge, as a result of that, we were able to...
Let me interrupt you. I am compelled to make sure that Mr. Knowles is not operating his motor vehicle while he's joined us via Zoom. It's fine for you to be in your car as long as you are parked and not trying to drive while you're in a Zoom hearing. I don't want to be responsible for a multi-car collision.
I'm having deja vu. Have we seen this before?
Yes, sir. I'm parked.
All right. You can hear us, though, right?
Both hands, yes. Yes, I can, Judge.
I apologize, Mr. Vandervoort, but believe it or not, I've had one senior attorney, and I'm not sure if it was senioritis that got to him, but Mr. Flanagan, I'm sorry, I didn't mean to say his name, was actually driving one day while he was supposed to be in a Zoom hearing with me. So, and I had to point out to him that that was highly illegal.
I feel compelled to defend him, Judge, and that we're being recorded. Maybe he should not make any statements.
All right, let's go forward.
Judge, so we were before the court on that date. The court moved the court hearing until today's date for the purpose of getting in contact with EDC.
This is your client, Mr. Sam Myatt, standing up. If you want to come up here and be seated at the table, you can do that.
He has issues
you can
hearing,
hear
Judge.
better.
Yes, sir. So, Mr. Myatt, you can come up.
Any of the parties that want to come up and be at the table for this argument, they can do so.
So, Judge, we were able to get releases finally on September the 6th. I proceeded to then contact DDC, and we have scheduled a conference call with DDC, which was when they were available on October the 30th. So thus the motion to continue the matter because it's presently set for September the 26th. That being said, Judge, I have filed a motion in the Betts matter requesting that the court proceed to disperse the funds partially in that case. I think in speaking with counsel, various counsel, Judge, I think my request is to go ahead and disperse funds that are undisputed. I think reserve maybe, I think Mr. Regent wants to reserve 10% of that. I think his proposal is, and that's fine, to reserve 10% of that for expenses that may arise. That way it's insured, it's covered. Disperse the remaining balance of those undisputed funds. The disputed funds being the potential heir of Mr. Myatt. Hold on to those in the clerk's office.
All right. So, and this is an issue that's come up before. there are a number of heirs that there's no dispute about. And those heirs' ability to access the money that would normally have already been paid to them have been hamstrung and constrained by this pending litigation regarding Miss Catherine Jean Myatt Rundle, who is that correct? Am I thinking of the right name?
That's right.
Who is a purported heir of Mr. Charlie Myatt. And if she is in fact an heir of Charlie Myatt, then she would receive a share of the estate. And that a share would be some
1/9, Judge, I think.
1/9, which would be equivalent to about.
Your Honor, I've run the putative distribution spreadsheet, both with her as an heir and without. If she is an heir, she gets about, and by the way, these numbers are exclusive of the interest that has been earned.
We're just talking broad figures.
About $222,000.
And if she is not an heir, then that $225,000 would be distributed among those heirs there's no dispute about.
Correct.
So therein lies the rub of where we are.
Yes.
And to my mind, there's no reason why those people who are undisputed heirs of the estate should not go ahead and receive their share of the estate. Now, there was some mention of reserving an amount. Is that correct?
Well, Your Honor, if we go ahead and distribute everything, then any future charges that are properly chargeable against a common fund would perforce have to come out of only that one share, whosever that is.
Good argument.
And if it turns out to be that Ms. Rundle is in fact an heir, then she would have to bear the entirety of the common fund expenses out of her share. That was why I suggested to Mr. Vandervoort that we leave some percentage of even the undisputed funds on deposit with the court.
You propose 10%?
Yes, Your Honor.
So how much is the pool of undisputed heirs?
At the moment, it is right at $2 million, give or take
So
some.
10% of $2 million would be $200,000.
That's admittedly generous, Your Honor. But then again, we don't know what's going to happen. And I would hate to find out that the money has gone out the door and needs to be got back.
Is there any opposition by anyone that's associated with this to reserving a 10% for any future issues, but distributing the monies elsewhere? I don't know why I even asked this question, so.
And again, no disrespect to Mr. Region, but I think the simpler process would be is for there is $200,000 approximately left in the that of cash monies in the estate. There is the secondary lawsuit of the partition suit. I would think and suggest to close out the partition suit would be that Mrs. Rundle's portion of the partition suit be paid over into the estate and segmented out, and it's an asset of the estate. If it could be, Mr. Region then could submit his final fee. It could be paid out of the general fund, and then it could be divided between the heirs, safeguarding Mrs. Rundle's portion. Then, if she's an heir of the estate, and then again, no disrespect to counsel and his ability to earn fees, but there's nothing left in the partition suit other than whether she is or isn't an heir. And any fees should be associated with the estate rather than double dipping, and you're paying an attorney for the estate and you're paying an attorney for the partition suit. So I don't know why we couldn't merge those if there's not an objection.
She wants to cut one of the lawyers
Mrs. Rundle's portion be paid into the estate and safeguarded through that, and Mr. Region could get his money, his final bill, and then he would be out. And then that would be just one less attorney that we have to deal with. No disrespect.
No disrespect, but can we cut this attorney out?
Yeah. It is the dispute, the disputed amount that if Mrs. Rundle is an heir or if she is not an heir, there's some certain amount of money that she would be entitled to. That could be paid over to the estate and segmented out, and then any fees can be paid through with if she's adjudicated not an heir, then there's $400,000 in the estate divided out between the heirs. If she is, then there's money to be divided that many ways, and then that way we're done with that other lawsuit.
But what does it take to resolve the partition suit?
Actually, Your Honor, I was going to say, Ms. Roberts has come up with a wonderfully creative and perfectly satisfactory way to fix this. There is
You do realize this is being recorded, right?
Oh, yeah. I'm perfectly aware that my words may be used against me. In any event, there is, however, a residual timing issue, because most of the money in the partition action is presently being held in a certificate of deposit. So we would need to wait until the current, and I think it's not more than about a 4-month certificate. It's what the clerk's been purchasing. So we would need to wait until that certificate matures. She can collect that because we don't know how much interest is going to be there. It should be something on the order of about $60,000 so far worth of the interest. So that would get added to the pot. But that would be my only suggested addition to what Ms. Roberts has proposed. I think that makes perfect sense. It gets me out, and she's right. There's no reason for me to be involved in this dispute. On the other hand, as long as the partition action is still open, I may be taxed with doing things like figuring out how much everybody's supposed to get.
Anybody else have anything input about this? Mr. Knowles, I know you're representing someone whose right to share in the estate is still up in the issue, but do you have anything you want to say about this?
You have to unmute, sir.
The little microphone, you just touch that little microphone. So.
I can.
I think I poked the wrong button. Can you hear me, Judge?
I can.
Okay. The only concern I have is, will this create a final order? And what I mean by that is the court going to be ordering that my client's funds be distributed to the estate, or my client's potential funds be distributed to the estate? These are two separate lawsuits. So that would be the only concern that I have.
Mr. Knowles, I don't know if you're able to hear, but Mr. Vandervoort objected on behalf of Mr. Sammite to characterizing any of these funds as being the Rundle share. What they will be referred to in any order that's entered is the disputed amounts. So if there's an order that goes down, it's simply going to say the disputed amounts are reserved until the resolution of that. So what we're trying to do, we have two separate lawsuits. Ms. Roberts has proposed that the partition action, which has still been open even though the property has been sold and the money is now on deposit in a certificate of deposit, that action be concluded and that the money be transferred over to those people who are entitled to it. And we close out that partition action, but pay over into this action to the clerk of the court any disputed amount that could be for an heir that would be determined, which would be your client, if in fact she was found to be an heir. Am I stating all of that correctly? Ms. Roberts, was that an accurate statement? So what we're trying to do is to simplify things, and rather than have Mr. Region continue to be involved in it, we can allow him to be basically bow out, conclude his file on the case, transfer the money over here to where everything else is. So I'm giving you an opportunity to voice any objection to that, but that's about what I'm about to do. So do you think you can talk me out? Go for it.
Your Honor, no, I do not. My concern is just that we're creating a final order in the partition lawsuit that vests funds with an estate that's then going to make a decision who should get the partition funds, which, in thinking through this, I think that would be okay, but that was my only concern.
Judge, well, Mr. Vandervoort, I think you've been wanting to say something. So.
Judge, I concur with Mr. Knowles' issue regarding creating an issue. If either party decided to appeal this, I understand his concern. We've created a final order. I think what the court, and I think all parties are wanting to do is kind of create a mechanism to get these funds to the rightful owners. But Judge, I guess what I would ask is, yes, we're fine with that form of distribution and for Mr. Region to be able to withdraw from the case, but simply leave the partition matter open for a final order, in as much as either party may need to appeal, and it would be applicable to the partition action. And so, Your Honor, for that reason, I would ask that I understand his concern, and I concur with his concern. If we're closing it out, it would be a final order, and we're not asking for it to be a final order. We're simply asking for it to just, our motion is for it to just simply be distributed. A final order may create an issue, and I certainly don't want to do that. So I understand Mr. Knoll's point.
Well, why can't we enter an interim order that basically provides that the order is going to reflect everything we were just talking about, but it will be styled an interim order that will conclude the partition action, but leave the issue of something, whatever has to be characterized about this. Ms. Roberts?
The order just needs to reflect that administratively you are merging the issue of heirship from the partition suit in the estate, and then you can close the estate and administratively merge that one issue of distribution, because nobody contested the partition. The partition was made, it was sold, we got court approval on the partition. So the only issue to be appealed, if you would be the determination of who the heirs at law are.
Which is the issue in this case.
Which is the issue in this case. So you just administratively merge that issue with the estate case, so that the issue is going to be, then there'll be one appeal if anybody appeals it, rather than two appeals. And you would just merge that issue with the estate, and I think that can be done.
I think Ms. Roberts has figured out how to skin the cat.
All right, since you two
I agree with that.
Since you two have now formed a little bit of a mini firm together, we'll let that be the way that we handle it. So, Roberts, the Region, we're going to put an order down that administratively merges the issue of heirship and the resolution of this section with of that disputed amount, but concludes the partition action. And the reason I'm doing it, there was no, as was pointed out, there's no objection to the partition or to the sale or to the amount that was received. So the only issue that could potentially arise for an appeal would be the distribution of that section, which directly is involved in this section, in this other lawsuit. So we're going to merge those two administratively. Anybody have any objection to that? Mr. Vander?
That language, I wouldn't have any, make sure it's clear.
A little bit of a creative relationship or creative solution, I suppose. You ever saw the movie Lincoln? Towards the end of the movie,
read the book, Your Honor.
He is Daniel Day-Lewis plays Lincoln. It's a great movie if you haven't seen it. But anyway, there's one section where they're arguing that he can't do something. He said, "I am the President of the United States. I am enclosed with immense power. I am not the President of the United States, but I'm going to clothe myself with immense power and say I am administratively merging that issue with this other lawsuit, and we're going to conclude the probate matter. Mr. Region can step aside and submit whatever fee petition you need to, and go from there."
Your Honor, what I would propose doing is, along with any final motion for fees that I have, I would like to propose, based upon once Ms. Collins has liquidated the current CD, a proposed distribution spreadsheet in an order that the court would then incorporate the spreadsheet into. So
you and your spreadsheets are very helpful to the court, so please feel free to spread away.
Thank you, Your Honor.
Court, maybe I missed, we're not closing the probate matter.
I can't hear him.
Did I misspeak? If I misspoke, then it is the partition matter that's being closed.
Right.
All right. Is there any objection to this motion to allow expert testimony via audio-visual. Then your motion for that would be, what about the motion to continue the hearing? I think it's reasonable to continue the hearing since we're obviously still waiting on some things. Then the only other thing, if I'm understanding, are two motions: a motion that the heirs and other interested parties be served pleadings, and a motion for a scheduling order.
Be totally candid with the court. I don't know that you have subject matter jurisdiction to grant my motions. And let me see if I can try to explain why.
That's a daring
there are
move.
Numerous problems with what has occurred up to this point. In particular,
who do you represent and who?
My name is Michael Betts.
All right. So you're one of the potential heirs?
Yes, sir. Matter jurisdiction. In order for the court to acquire subject matter jurisdiction, according to TCA 30-1-117.
Are you a licensed attorney?
Yes, sir.
All right. Go ahead.
It says that the petition must
checks his bar card.
state.
Let me again ask you specifically so that I understand. You're alleging that there's a question of subject matter jurisdiction?
Yes, sir.
In what?
And personal jurisdiction as well.
In what?
In the probate proceeding.
Okay.
And the reason is I think that the petition itself is defective, and that the statute requires that the petition lists the name, the age, if known.
Have you filed a pleading on this issue?
No,
Have you
sir.
filed a pleading on this issue?
On the
I know that you filed a motion to serve all of the parties, all of the respective people of interest, but I wasn't aware if you had filed a motion. Of course, I hadn't had a real chance, but you filed a motion contesting the jurisdiction of the court?
No, sir, I have not. It wasn't until after I filed this that I'm one of the people who has never been served anything dealing with a probate proceeding. And I've heard from other heirs that they are not being served everything, and they said that what I'm being told is that they're actually having to call other heirs to find out what's going on with the case, because some heirs are being served some things, some heirs are not being served others. It's a hodgepodge mixture, and I was not aware of everything that had occurred.
This is Michael Andrew Betts, plaintiff, versus Janie Eudora Myatt.
They're all suing each other. It's nuts.
You mind, let's see if you can find it. Maybe. This is the Robert Herman Herald. That's not the same.
Well, he's reading. This is a case where there's an heir, a child, illegitimate child, I believe, that is claiming to have, to be owed 1/9 of the $2.2 million estate. And obviously the other kids who knew nothing about her are like, nope, we don't know who she is. Judge ordered a DNA test. They got the DNA test. The results came back.
Well, what I have before
and
me,
they're
Mr.
disputing
Betts,
that. They're still fighting.
If I'm missing something, I have a motion that heirs and other interested parties be served pleading. That was filed September the 11th of this year. I have a memorandum of law in support of the motion that legal heirs and other interested parties be served pleading. And I have a motion for a scheduling order that you have filed. And then I have the motion to allow the testimony via expert witnesses. So what I'm questioning is, did you file a specific motion under the rules challenging the jurisdiction of the court?
I did not style a motion specifically like that. It's in my memorandum dealing with the motion to serve the heirs, that the process that's been employed thus far, I believe is unconstitutional. Because again, if Ms. Rundle is to be deemed to be an heir, that's going to affect my percentage and every other heir's percentage. So therefore, we're entitled to notice and an opportunity to be heard. I have not been served anything. And what I'm hearing from some of the other heirs is that they have not been served pleadings. And I was not aware of how bad this was up until after I filed that, and I had heirs contact me saying that they were hoping that I would get involved a long time ago, but I said I couldn't because I was never served. I was never given notice.
So he's made decisions.
I wasn't even aware Your Honor's name until I called the clerk to find out who you were. I've never seen one thing with your name on it dealing with the probate case.
Right, so you're saying that your position is, at least if I'm understanding you correctly, that if Mr. Knowles has filed a petition to declare this individual to be, or a motion to declare this individual to be an heir of the estate, and he served that upon the administrator of the estate or executor of the estate, that was insufficient and he was required to serve each and every heir of the estate?
Yes, sir, and as well as the Attorney General. Because again, by statute, she is not allowed to take from the estate. And the only way that it's going to become relevant is if that statute is deemed to be unconstitutional. According to state law, as well as the rules of civil procedure, if you're going to challenge the constitutionality of a statute, as you're very much aware, you have to give notice to the Attorney General and a reporter so that he can come in and defend it. From what I've been able to gather, again, because I haven't been served pleadings, is that they're almost doing a discovery without giving notice to a indispensable party, i.e. the heirs of the estate, as well as the Attorney General. So I just don't see how, I'll just be upfront with you. I don't see how this court has subject matter jurisdiction or personal jurisdiction.
That's a slap to the face of the judge.
Let me hear from the opposing parties, but I mean, it seems to me subject matter jurisdiction is conferred upon the court by the fact that it is a probate matter that was opened in this court. Part of the probate matter in any jurisdiction, in any probate case, is to determine the heirs at law of that person. So, you know, the question of subject matter jurisdiction, there may be a question legitimately raised about the procedural aspect of notice to any claimants under the estate, but as far as subject matter jurisdiction, it doesn't appear to me that that's a problem wherein it's a petition. This court, by a state act, transferred the probate matters to the Chancery Court of Dixon County, Tennessee. So the probate matters are here by a private act, and that is an act of the state legislature. And that act confers upon this court subject matter jurisdiction over all probate matters. Now, your argument about subject matter jurisdiction over the issue of whether or not this claimant, Ms. Rundle, is or is not an heir of the estate is based on, I mean, I'll have to review what you argue in your pleading, but it seems to me that that is a corollary matter to whether or not this court has subject matter jurisdiction over a probate estate. So.
If I may, Your Honor, and Turner v. Turner, the 2014 case from the Tennessee Court of Appeals, this is what the court held. It says, failure to adhere to the Tennessee rules of civil procedure in giving notice and serving process have been held to deprive the court of personal jurisdiction over the defendant and result in a void judgment. It's not voidable, Your Honor, it's void. So I assert to you, I'm willing to let it proceed, but it's just the fact that there's so many parties involved that are bickering with each other that I don't want to see this court enter a order that is void that someone's going to take up to the Court of Appeals and it's going to be sent back.
All right. Anyone have any?
Who wants
Knowles,
to argue
you have
that
something
one?
you wish to respond to this?
Mr. Knowles, did you forget to notify people?
Judge, I guess to some extent I believe that Mr. Betts had counsel, at least in the partition suit. Am I incorrect?
Mr. Betts?
The answer to that is yes. Mr. Regan represented me in the partition matter. However, it's two separate matters, two separate cases.
I'm well aware.
It's almost like if I received a speeding ticket and someone's trying to repossess my vehicle, this court has jurisdiction over the speeding ticket that I got in the vehicle, but doesn't necessarily acquire jurisdiction over the repossession.
So the reason I say that is because I can't dispute that possibly on my certificate of service for estate matters that I filed, and I'm only speaking for myself, that those were sent to his counsel instead of him in the estate along with in the partition suit. And I realize that those are separate issues, but that's the only thing that I see. I don't see where there's been any form of notice of appearance or anything else submitted in the estate. But I submit to the court that you absolutely have subject matter jurisdiction. There's no question about that. There's no issue with subject matter jurisdiction here.
Mr. Vandal, do you have anything to say?
Judge, I'm
Well, there you go.
Judge, I don't think we received a copy of that portion of his motion. If I have, I just don't recall seeing.
Which motion?
His motion on personal service.
He's flipping over saying,
Mr. Betts is arguing.
Yes, sir. I don't. And
you didn't serve the other attorneys.
Another motion for a scheduling order. So I'm not here. I can't really speak to it. I agree with Mr. Knowles. There is subject matter jurisdiction, but if there is an issue with personal jurisdiction, it would obviously involve service and that type of thing. But I just haven't had a copy of that motion.
This could set the whole process
I've sent it to him twice.
back
I can
to
give
the
you the
beginning.
receipts if you would like to see them.
I'm sorry.
From the post office where I mailed them to him.
What? Ms. Roberts?
Any notice pursuant to the rules of civil procedure that he cites, it would have been a violation, ethical violation, as well as a violation of the rules of civil procedure for us for anybody to send pleadings to him directly, as he was represented by counsel in the partition. So the rules of civil procedure and the statute that he cites, he received notice in the partition suit via his attorney. Now, in the estate case, he is an heir. He's not a defendant. So the rule of civil procedure that he cites is not applicable, as there is not an adversary proceeding that in the estate case he is an heir. Now there is the disputed of Ms. Rundle that is proceeding as to whether she's an heir or not, and I can't speak to whether what he got or did not get as an heir in the estate case. So when you're talking about service of process is different than notice. So I'm a little confused over the question of constitutionality. I don't know that there has been, if he has served the Secretary of State to challenge the constitutionality of the probate statute in the state of Tennessee, I'm not aware, and he has the right to file that and to contest the constitutionality. That's on him, that he has to give notice to the Secretary of State.
I'm going to pause this for 1 second and give you just a little rundown what's happening here.
But as far as what he's citing as far as subject matter jurisdiction, Mr. Myatt died a citizen and resident of the state of Tennessee and lived in the county of Pickles, property owner in the county of Pickles.
Okay, let's pause right there. Everyone except for the gentleman with the red tie who's standing at the podium, who is one of the heirs. Everyone agrees the judge has subject matter jurisdiction, which he does. That's given to him by the legislature. The law says he's in charge. It happened in his county where he's judge. It's the right court. It's the right place to handle this. But the guy at the podium thing is saying this is all voidable because you're making decisions with only some of the family here, and it affects all of them, and they haven't been given notice. I didn't know what was going on until just recently, he says. Turns out he is a lawyer, so he previously had a lawyer himself represent him when they were dividing up the amount, but that's a separate issue from whether or not there's another person to divide it from or something like that. So he's got this, he's like, well, I'm representing myself here, and so he's basically throwing in the, you screwed up back there and I can make you all back up and start over again. Nobody's talked about the DNA yet, but I'm hoping that happens soon here.
Jurisdiction for that probate estate to be filed. The court has subject matter jurisdiction over the administration of that estate.
$2.2 million.
Mr. Betts submitted himself to the jurisdiction of this court by filing a partition suit and bringing that matter before the court. So any objection for service for jurisdiction on the partition suit, I think, is waived because he instituted the petition himself and submitted himself to personal jurisdiction of the court. So again, under that estate matter, I think there's an effective waiver. He submitted it and admitted there was subject matter and personal jurisdiction. As far as the estate is concerned, his whereabouts and what was going on is not relevant because Mr. Myatt was a citizen and a property owner, and this is the correct venue, jurisdiction, both subject matter and personal, over the administration of his estate. Now, whether or not he has properly, and there's been some violation by any of these lawyers by not sending him notice appropriately, again, I think he's listed on the certificate of service, but again, it could be that mistakenly we
well, I'm going
to Mr. Reed.
I'm going to break for lunch so that I can read through what exactly Mr. Betts has filed and the challenges he's raised. I have a copy given to me of the Turner versus Turner, and I need to read that case as well. But we're going to take our lunch recess. We'll be in recess to 1:30. I'll come back at that time and give you my opinion on this motion.
All right.
So we're going to skip the lunch break and see where this goes, because he's got an hour to think this one over.
Now to recess.
Well, he gnaws on a Subway cold cut. Let's see. Skip. And he's back. There we go. Just waiting for the judge. Here he goes. Comes in.
All right, we're back. We have everyone here for.
Mr. Knowles made it to his destination, but his camera has a pink line in it.
All right, I've reviewed the case that was cited, Turner versus Turner, and I've looked more closely at what Mr. Betts is arguing about the situation. So anybody else want to be heard on this argument? He's in the back, or Mr. Odell. Mr. Knowles is here. Where is Mr. Odell?
Mr. Odell's late back from lunch.
Anybody else want to be heard on it? Question before the court is whether or not there is due process being followed. Mr. Betts has argued in his motion that the heirs and other interested parties be served with pleadings. The argument that he makes in his memorandum is that we are depriving him of due process under the 14th Amendment because he is an heir of the estate without dispute, and depending on how the court rules regarding Ms. Rundle's claim, his share will either be decreased or increased, and therefore he has a financial interest in it. The case that he has cited which is Turner versus Turner, is a termination of parental rights case. And in that, there was no personal service on the defendant whose rights as a parent were terminated. And instead, they proceeded on a default basis and after serving by publication. Under those circumstances, the Court of Appeals, in considering whether or not there was proper service, did make the comment that without proper service, that there was no personal jurisdiction, there was no subject matter jurisdiction or personal jurisdiction. This court is of the opinion that there is a distinction to be drawn between what we call subject matter jurisdiction acquired through the subject matter of a proceeding and through the proper process on anyone that might be a party to the action. The heirs in an estate are not parties to the action. That's the way that I understand it, at least. Heirs to the estate, anytime that there's an estate petition to open an estate where heirs are listed, they may be given notice, but they're not be required to serve with process, an actual summons requiring them to file an answer in the case. In this particular case, there are numerous heirs that have been brought to the court's attention. I don't know how many there are, but there are a lot of them. And they are all entitled to notice, I believe, of the pleadings and notice of the hearing. But as far as serving them with process, I do not think that is required because they are not defendants in a case. Under the rules in the Turner case, they talk about a defendant being, someone who is going to be made a party or a defendant has a right to be served and be given an opportunity to respond. That is different than in a case where an estate is opened, as in this case, and a proper pleading was filed to open the estate, and notice was given by mail to the purported heirs of the estate. So this court will rule that from henceforth, anyone who's listed as an heir is entitled to notice of all proceedings and notice of all filings. It will be cumbersome if necessary, but I think to that extent, I'm granting Mr. Betts's motion that the copies of the pleadings and copies of anything else be served on anything that transpires in this case for hearings or anything else. These parties who are the heirs, the individuals who are heirs, I think are entitled to notice of those issues. But as far as this court's ruling, this court is ruling that in the opening of an estate and a properly filed petition to open the estate, the court acquired subject matter jurisdiction over it, and that it is not the practice of this court nor any other court that I'm aware of that requires that any potential heir to an estate be served with personally served with process and have to file a response as a defendant would do in a case. I think they're entitled to notice, but notice versus process are two different distinctions in the court's mind. So, Mr. Best, is that clear on my ruling?
Yes, sir. I do have one question, though. What about the issue with
Why would the Attorney General have to be served? Only time the Attorney General is given notice is if there is a challenge to the constitutionality of a statute.
state law does not allow her deemed to be an heir of the estate? You could become an heir of the state as if the state law is declared unconstitutional.
Anyone challenge the constitutionality of that? No. Then what the cart is before the horse. You're arguing that the state law doesn't allow that. We have not reached the point where I would make a ruling on that. And no party in this case has filed a challenge to the constitutionality of the statute. So therefore, there is first a factual issue as to whether or not she would or would not meet the criteria. And secondly, then only if there is a challenge to the constitutionality of it, would there be a need to serve the Attorney General of the state of Tennessee. So your motion to serve the Attorney General is respectfully overruled. Anything else? And that will conclude our hearing in this case.
Judge, I have one question. Sorry, I couldn't get my microphone off.
We have a certificate of service that I believe all counsel is using effectively the same. Are the heirs going to notify all of us or someone if it's the wrong address on it? I mean, we can only proceed with the information we have.
I'm assuming Mr. Betts says he's been contacted by people who say they don't know what's going on. The only thing I can do is to say that all parties are to be given notice according to the certificate of service. If their address is incorrect, then it's incumbent upon them to obtain the correct address and make sure that it's filed with the court.
May we get Mr. Betts' address to ensure that he is properly noticed?
I think it's on his pleadings.
It's on the pleading.
I think it's on the pleadings.
I assume that I got his pleadings and he had an address on the pleadings.
I don't want to announce his address online. I'm wanting to say basically his address is shown as, as it is on the pleadings he's filed with the court. So, Mr. Knowles, all parties are to be served with notice that the address that has been shown in the past, if someone is saying they're not receiving it, they need to double check on what their address is, and they are entitled to, and Mr. Betts can assist in distributing that information to the other parties, but they can, if their address is incorrectly shown on the certificate of service, it's incumbent upon them to let us know if we have a different address.
Thank you, Judge.
Thank
So,
you.
Your Honor, if the ruling is just that if you're going to, that you deny the motion for subject matter, that you find that you do have subject matter and personal jurisdiction, and that from henceforth, all counsel will ensure that all parties, all heirs, are forwarded notice of any pleadings or other filings with the court.
Copies of any pleadings or other filings and notice of any hearings.
I don't mind drafting it. If
Let's just let you draft that order.
To make sure that was correct ruling.
Also include in that the court does not at this point in time find that there has been a challenge to the constitutionality of any statute which would require the service upon the Attorney General.
Yes, sir. As I understand it, he would have to file a deck action about doing that, but Your Honor hasn't ruled on what statute, whether she is or isn't, so I don't know what statute he's claiming is unconstitutional.
Well, all I'm saying is that at this juncture, in this status of this case, no constitutional challenge has been made to the statute. Therefore, there is no requirement under the law to serve the Attorney General. That may yet come, but I'm saying it's not here now. All right.
On my motions, I'll draft the order and submit it to the court.
That's fine.
Thank you, Your Honor.
This is just order I'm doing.
The judge has closed this file and set it aside. He's done. He's ready for the next one.
Thank you.
Okay. We're going to
That
pause.
brings us to Vicki Adams versus Kimberly Davis.
We're going to pause that one right here. We're going to go join him live. Let's see. Why is that button not working? What did I do to break my my Stream Deck? Do it this way. Before we join him live, let me just say this case, this DNA case that we've been following, it was spicy. It was crazy. I believe this is the one where they had like a really old, like a brother of the decedent or something, who got up and was testifying that, we all slept with her or whatever. It was crazy. It was wild. It was like we all took turns. It had some just like what underage, all sorts of things. So this family has a few skeletons in the closet. All right, let's jump over to live. He is not at Heavenly Wood, but the same judge is holding court in another county.
She's got a small savings account in her name. Is that
Humphreys County?
What about that?
Well, now that would be a little different. That's why I was asking you if that was the only thing in her estate. She had a savings account.
She has a savings account, yes. And my name is not on it.
Well, in your petition, you don't list that savings account, so you need to go ahead and add that to this petition and let that be filed. And we'll go ahead and open a small estate if you have both of those. So that Volvo could be probably handled by the clerk but since we're going to have to open the estate over the transfer, did she list you as the beneficiary of that small savings account?
Yeah, everything was supposed to go to me, and the way it was. If she passed away, I got everything. You know, if I passed away, she got everything. That's the way it was.
But I'm asking you, with the bank, where's the savings account?
It's in what's the name of the Apex. In McEwen, Apex Bank in McEwen.
All right. Have you checked to see there's a survivorship on certain accounts? Have you checked to see if that will automatically transfer to you?
They said they said no, they didn't know, I guess.
Okay.
Christina, congratulations on 1 year.
Trying to help you avoid having to file this small estate, but it looks like since you don't know the answer to some of those questions, it might be to go ahead and do it. I'm going to hand you back these documents. You need to file. Or fill out this form to show that savings account, how much it is, what the account number is, so that you can get the right to do that, okay?
Okay.
And then you take these back to the clerk's office when you have them finished, okay? All right, and back. I want to make sure you understand what page I'm talking about. On this piece of paper where you've listed the Volvo,
yeah,
it needs to be added to it, that savings account, okay?
Okay, thank you, sir.
Then take that to the clerk's office when you get that finished.
Okay, thank you.
A couple of you are asking, well, we have a break here. A couple of you are asking about Judge Boyd. And yes, there's a case, I think it involves 3 police officers who shot and killed a woman in her home in San Antonio. And she is there. The argument is that she should be recused from the case, and it's the argument they're using is her YouTube channel is a problem. They're basically saying that the judge set up this YouTube channel to sort of increase her own notoriety and everything there, and that as part of her setup and included a huge big screen TV and it installed at her mom's house so her mom could watch her work all day, every day, and her mom calls in all the time. And at one point, the judge was going to let somebody go. She was going to make decision A, and then the mom called. They talked for a minute, and then the judge changed her mind, and the attorney's saying because of the phone call, which would be inappropriate influence on the judge. And yeah, it's a little wild. We can't watch that one. That's not one that I can show you here on this channel, but it's out there. So they're claiming that she is using her YouTube channel to bolster her appearance, to humiliate attorneys, you name it. It's all in there. It's crazy. These guys, it's sour grapes, I think is what it is. But they might get her thrown off the case as a result. Let me see if Judge Simpson. Oh, speaking of Judge Boyd, she's back. She's up right now.
January 24th. 23.
And as a result of that, has that required some substantial life changes for you?
Yeah, I can't see out of my right eye, and I have been going through physical therapy. I had to learn how to walk again, and lucky to be alive.
Have you decreased or substantially changed your pattern when it comes to mind-altering substances?
Yeah, I have to stay clean because of my aneurysm, because I can rupture it and it can kill me.
Now, in your PSI, you indicated a willingness to perform any conditions the court required. Is that a true statement?
Yes, sir.
And one of the recommendations perhaps would be drug offender education program.
Yeah.
Are you willing to take urine tests weekly if the court ordered it?
Every day if I have to.
And the amount of medical care required, where do you receive that and how do you receive that?
I get disability. They have me on disability.
And where do you go for your treatment or medical care?
The neurologist.
Neurologist?
Yeah.
Okay. And who is that?
Dr. Morton.
And where does he practice?
The Baptist Methodist Hospital.
Now, as far as living arrangements, have you made appropriate arrangements with family?
Yes, sir.
And tell us briefly, are you married?
Yes, sir.
And who are you married to?
Patrick Harris.
How long have you been married?
20 years.
And do you have a close relationship with any brothers or sisters and parents?
Yes, I do.
And where do they live?
Odessa, Texas.
In your pre-sentence report, you indicated that there were some places that you might ask the court to transfer you to.
Dallas, Texas, or Odessa.
And why is that?
My husband is in Dallas and my parents live in Odessa.
And if the court required you to live here, could you find appropriate?
Yes, I have address here.
Okay. Now, as far as any type of plans for the future, if you look, say, 2 or 3 years in the future, where do you see yourself being?
Going back to school.
And what kind of school you'll be back going to?
To finish my GED and hopefully try to learn something in college, something. I don't know exactly what to do, but something different.
Finish GED and hopefully learn something in college.
At this point?
Be a mom, take care of my kids.
And when was the last time you held them or touched them or saw them?
5 months ago.
And what's it like for you being in a prison or a cell?
It's difficult because with my aneurysm, I can't have stress. It's the headaches. And if I do, my blood pressure, I'm not really able to get the medical care I need to get.
And did that happen last week?
Yes, I was in the hospital last week. They took me.
Some might say that raising children is very stressful, more so than a jail cell. What are your opinions on that?
I mean, being in jail is way worse because I can't eat right. I can't, keep my blood pressure right.
Do you have blood sugar issues also?
No.
Any other issues that you're aware of?
Well, not if I'm aware of.
And the medicine, do you know the regimen of prescriptions you're on for your blood pressure and aneurysm?
It starts with the I, and one of them is nematol, and then the other one is baby aspirin, and the blood pressure is, I don't know. It starts with the I.
Okay.
I don't know how to pronounce it.
And how would you get those medicines if the court were to grant you some sort of supervision?
With my disability, the insurance.
Is there anything else that you'd like to tell this court that we haven't covered?
No. I just want to be able to get the medical care I need to finish my physical therapy.
Ask the witness.
State? I only have a few questions. In your PSI, you mentioned that in regards to this offense, that we're doing something, you kind of figured out what it was, and you put your trust in someone. What did you mean by that?
Well, I thought that they were, my friend, I thought they were like family to me, but they turned out it wasn't.
I'm sorry, they turned out what?
It turned out to be something that it wasn't.
Okay.
And as a result of this incident, did you attempt to rectify it with the police department?
Yes, sir.
Did you attempt to help them?
Yeah.
And did you accept responsibility, acknowledge guilt in this case?
Yes, I did.
Nothing further, Your Honor.
All right, any other questions?
No.
All right, how old are your children?
She's 6, 12, 13, 16.
Parenting
right.
classes.
And where were your children during this offense?
With my husband.
And that's the person you've been with for 20-something years? So from reading the police report, it appears you knew you were transporting drugs.
Yeah, I kind of figured that. I was.
Well, I mean, what do you mean you kind of
I
figure?
knew I was, yes.
Okay. And it was transporting a lot of drugs. Why would you transport drugs?
I was doing a favor for a friend. I was taking something somewhere for somebody and I didn't know exactly. I kind of figured it was what it was, but I didn't think about it.
No, it says in the police report, and I don't know if you've had a chance to review the police report again, but in the police report, you get pulled over.
Yes, ma'am. I knew I was doing what I was doing.
All right, because it says here, I began speaking with S1, that's you, who still appeared very nervous. S1 began speaking to me about where she was headed. I temporarily muted my body cam because S1 began speaking about information, that should be confidential. And then they say that you actually admitted you were transporting drugs and that you knew you were transporting drugs.
Yes, ma'am.
So I don't understand when you say that you figured it out later.
Yeah, when I got pulled over, I kind of realized it was something that,
So you're saying in the very beginning, you had no idea until you were pulled over?
I didn't think it was what it was that I was taking. Because it was wrapped up. It was like in a box and everything. So I didn't know.
So you're saying that you didn't know what you were possessing?
At first I didn't.
So when did you discover what you were possessing?
Whenever they pulled me over.
All right, state. Any questions?
No, Judge.
Defense, any questions?
No, Your Honor.
All right, you're saying you didn't know what it was. Do you want a jury trial?
No.
All right.
Just want to go ahead and get this over with so I can get on with my medical care.
All right, court will hear final argument. Defense.
Your Honor, as the court has perused the PSI, has gathered some information that indicates the client that has physical disabilities and opportunity to provide information to the officers. Also, she has admitted guilt, has had difficulties in this jail system with getting appropriate medical attention. And we respectfully ask the court to grant some sort of supervision.
State.
Judge, it's a very large amount of drugs. Just from the PSI and just from the police report, the defendant knew what she was doing. Again, that's why the state was opposed to any applications. So that's why we're opposed.
All right. So, Ms. Moore, I'm considering, of course, the facts of this case, and then sometimes our history follows us around, right? And your history, you've been on probation before, and you were unsuccessful. You were revoked. And then this case, it's a lot of drugs.
Yes, ma'am, I understand.
Okay.
I'm older now. Back then I was young. I didn't have the resources then to do, but I know I can complete the probation.
All right. So here's my question though. Where was your husband in all of this?
At home.
So he had no idea that this was going on?
Yeah.
So he had no idea that you had a drug problem? Is that what you're telling me?
No, he knew I had a drug problem.
And he had no idea you were transporting drugs?
He didn't know what I was doing.
And has Child Protective Services been in your life?
Yes, ma'am.
With your children? And
I want to hear how much
so you're saying your children have been placed with your husband?
Mm-hmm. It's nap time right now. I'm
yes,
so
ma'am.
tired.
For how long?
They've always been with him.
So what did Child Protective Services do then?
They just left them, but they didn't ever come to my, they didn't ever do nothing.
Okay. All right. The court is going to find you guilty. The court is going to sentence you to 4 years in the prison. Give you credit for any time served. I'll request the therapeutic medical unit With that unit, you'll have to actually request it as well because I have no jurisdiction for them to place you in that unit. But that unit will help you with any drug issues you may have, any physical medical issues or mental health issues. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? Yes, sir. All right, we can go off the record. When you're released from custody, you need to make sure that you get back on track, being clean and sober. You understand? If you have an issue where you can't find a place to help you with that, if I'm here, you can always come back to the court and I'll direct you to a place that can help you. Good luck to you.
Must have been a lot of drugs. Yeah, while she's thinking here, let me tell you about my weekend. We didn't get hit hard with the hurricane, right? It wasn't bad. But our roof, I think, got a little more damage, and so we have a second company that was supposed to show up before the storm hit. They didn't show up. And now that the storm's hit, finding a roofer that will work on a small job like this in North Carolina is virtually impossible. So no, our roof's not repaired yet. No one's going to come fix it when they have big money jobs that they can take instead. And then on Saturday, we're going to go do a church thing together as a family. We're headed to Raleigh. I'm all in my Sunday clothes, suit, everything. Everyone's in the car. I'm the last person out to climb into the car. And as I step out to the car, I hear rushing water. There's no water that should be rushing around my house, and it's coming from my basement. And so I pop my head down the basement, and things are just floating down there. Just all bins, they're floating, tools, everything flooded. And so luckily I was able to put on, I've got my Arctic muck boots. I was able to put those on and wade down through the water. It wasn't like over my calves or anything, but wade down through there and fix the sump in like white shirt, tie, dress pants. I took my suit coat off, and in doing that, I'm like, trying to fix something because I'm like trying not to stand in water that's deeper than my boots are. Completely just hook my white shirt, which is brand new. I bought it when I was in Utah. I hook it on a nail, just tore the sleeve open. I'm like, oh, but it didn't scratch me. I still need to go down the basement and just see. We've got it pumped out. It's clean and dry, but I just need to see what didn't survive. I know my generator was down there on the ground, and I'm hoping it survived. Weed eater, things like that. I think my chainsaw was up higher, but yeah. So seriously, I'm looking at Land Watch and Zillow and eyeing all these desert locations, thinking that's looking really good right now. That looks really good. I'm in eastern North Carolina, not far from Greenville. There's a lot of Greenvilles. There's a Greenville in South Carolina that's bigger. I'm in Greenville, North Carolina, not Greensboro. Put it in rice, it'll be fine. Yeah. It's just been, and then on top of that, trying to help out with North Carolina, the western part of the state, and working with crisis cleanup and everything like that. It's been a weekend and a half. I just have not slept. So, generator might be okay. The oil is supposed to prevent water intake. It wasn't running, so that's good. It was a long weekend. It was a long weekend. What caused it to flood? The amount of rain we got, the water table rises. Our basement is literally below the water table. What happened was our sump pump, which is at the lowest point in the basement, in starting and stopping and starting and stopping as it normally does in the normal function of, home ownership, it blew the seal between the pipe that it pumps the water out and out through the to the discharge area. It blew that seal, so it became instead just an indoor fountain. And so water just kept coming in and geysering, and I did not hear it until I was standing right next to the car, and I could hear it coming from underneath the house. And I mean, comparatively, my house is still here. It did not get wiped away. I'm not dealing with 6 feet of mud in my house and everything else. So I'm doing well, but it's like I just didn't need that on the list as well. Anyway, so that's why I'm a little bit sleepy. It's been a long weekend. That's why we don't have basements in the south. The water table, I know, but they dug one in ours, and that's where our heater is. So the flood water was up to just below the circuit board on the furnace, like just below. So the furnace is okay, even though there was water in the furnace. It was not shorted out and destroyed. So it was so close. Yes, we've had 2 water features. We have the fountain, the rainfall, the sounds of the rainforest upstairs in the master bedroom, which is, you also get the moisture of the rainforest as it rains inside the master bedroom. And then we have the fountain downstairs. So I am super lucky. I'm not complaining. I'm looking at some of the videos that are coming out of Tennessee and North Carolina, Georgia, Florida. It's just, I got it really good. Let's see. When it rains, it pours. It rained a ton. People pay good money for those features. Well, now I know all about how to make one. Kimar, North Carolina having mold, that's like saying welcome to North Carolina. Mold is just one of the things you deal with and treat constantly. Ring makes flood detector alarms. We keep several in our basement. Mary, I don't know. Hosky's is quite a ways away, I think. We have local companies, but the work that just became crucial because of this storm, everybody is now doing big roof replacements. And I've got a little repair. So we'll see. Shelly Kelly, welcome to the gallery. Thank you so much. It's so devastating. No more Chimney Rock. Yeah, Chimney Rock gone. Just wow. But, I mean, at least it was clean water. It was groundwater that came up. There's no rainwater that goes down into the basement. It's groundwater that comes up. So every time it rains a lot, the water table rises considerably. And that's what I was dealing with. We're all good, though. Everyone's healthy and happy. I'm just looking forward to moving to dry place. Boone was devastated by flooding. We just barely stayed in Asheville, Boone area for an Airbnb as a family. We went there. It snowed when we were there. It was before our last trip to Utah, but we went there and loved it. It was beautiful. Went by the Biltmore Estate. It's a gorgeous, gorgeous town. We played in a little park that has a little river running through it, and just had a blast. There are pickleball courts and everything. That park's no more. It's gone. Yeah, Wagger, this is the dilemma, you know. Do we send everybody to do a little tiny job, or do we just cash in on the big bucks that we can? Kiki's Garden member for 15 months. Thank you very much. Yay. Hi, friends. Your positivity after unfortunate events is a great trait to have. Lucky to be part of this community. I'm fine. I'm just tired is all. I'm perfectly happy. I am closer to moving though now than I've been in a long time. Amber. I'm done. Biltmore was damaged. I remember vaguely RA scoffing at the contractor's offer. Yeah, that was not a vague thing. I spent a fair amount of time doing that. Now I'm like, please, sir, if I pay a little more. Detectives, I've always been a big fan of Alaska. Unfortunately, it doesn't have good, reliable, fast, high-speed internet in the areas where I want to live in Alaska. Because I just want to have either my own little island or be on an island where I have waterfront, so I can fish for crabs off the front porch, and maybe salmon, and watch whales and everything else. Check your burners, says BG. Just 1 second, we'll do that. Sent a couple pics. Oh my goodness. Sarasota County, Florida. Oh my goodness. Like, hey Scott, a house I checked on located in Minnesota Key Road, Inglewood, Florida. These pictures are the house, the whole first floor was underwater. Like, I think the ceiling of the first floor is damaged, and the walls are gone. Yeah, mine's not so bad. I'm telling you, I'm very fortunate, very fortunate. You can't move. Kaylee's looking to move to North Carolina. North Carolina is beautiful. I love it. There are so many things about North Carolina that are just amazing. RA moving to Martha's Vineyard or Nantucket. You two must be paying well. I'm not moving either of those places. Alaska, just the idea of living in Alaska is, for me, it's really appealing. In reality, moving to Alaska and having to like fight off the bears and the moose and the wolves and whatever else that wants to eat me every single day, while still trying to pay top dollar to get the basic necessities shipped to wherever I happen to be living in the remote tundra. It's not very appealing. That part isn't. 8-hour drive just to go to Costco. I've seen some of those channels. There's a channel up there. There's a husband and wife team, I think, and they've got this homestead up in Alaska, and they take their ATV to like there's like a railroad that goes through, and it's just a stop. It's just like literally the train just stops on the track as it's going through. It can't turn around. There's no side exit. It just, you wave it down and it stops, and then you hop on and it goes. And it's like a day trip. You take the train forever until you can get to a place where you can borrow a car. You can drive for 4 hours to get to Costco, and you buy stuff and you haul it back to the train station. You package it in crates, load it in the train station. The train comes back out, it stops, offload it there in the forest, then you load up on the ATV. It's nuts. I don't think I could do that every time I had to go to the store. Just buy a big RV and travel the country. Can always run from bad weather. With enough Starlinks on the roof, I could get fast service as well. That's the thing. I need so much bandwidth. Couldn't handle the lack of sunlight. Well, it's only lack of sunlight for half the year. The other time, it just doesn't get dark. Is your house on stilts? No, mine's buried deep in the ground. There was not a basement when it was built, but they dug a basement, a dugout basement, and then cemented it in. So it's supposed to be a dried-in basement, but it's not so dry. Hang on, something's happened with Judge Boyd. 1 second.
Apparently behaved inappropriately.
Okay. All right, we're back on the record. Counsel, have you received all of the discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Garza, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented? Any objection?
No objection, Your Honor.
All right. Did you review the document entitled Court Admonishments with your attorney?
Yes, Your Honor.
Did you understand it and sign it in all the appropriate places? Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram?
I do.
That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility. and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand?
Yes.
Did you understand you have a right to jury trial?
Yes.
A right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does.
And do you believe she's currently competent and was legally sane at the time of the offense?
As we stated earlier, Your Honor, she was declared competent on Friday by Judge Carruthers after a report by the physicians and workers at SASH, and I haven't seen any indication that she is not competent.
Ms. Garza, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial.
Okay, I'm going to try to find Judge Simpson. Josh sent me something that says you got to watch this. It happened while we were watching another trial. Give me just 1 second. Judge Cedric Simpson. It happened last week. There was a court case. The remote's not working very well. What is happening? Well, now it's all broken. Par for the course here. There we go. Okay. Judge Cedric Simpson. This is not it yet. Just 1 second. Channel. Something spicy happened on. There he is. Looks like he had a trial of some sort. We want to watch this.
Take you off.
Let's fast forward just a little bit. Let's get the judge in here. Oh, there he is. We didn't have to wait long.
You may be seated. All right. Mr. Bloom is not present. Is there, on the Jeffrey Bloom matter, is there anything that we'll need to take care of before Mr.
I have nothing, Your Honor. I would just say for the record, I have talked to all three of my witnesses and instructed them that we're not going to discuss the fact that Mr. Bloom is currently incarcerated during the trial, and that I will not be asking him any questions to elicit that type of testimony. I don't anticipate defense either. I expect 2 exhibits, Your Honor.
Well, exhibits in terms of paper exhibit?
I have videos, I have 1 video, and I also have paper exhibits that are the victim's medical records.
Okay. And Springsteen, you've gotten both of those?
Yes, Your Honor.
All right. And you know, in terms of the video, you know what, I don't know how it's broken apart. You know what portion will be played?
There's a 10-minute long portion that shows some before interactions and then the alleged incident and then it ends. It does not show the cell extraction. There are other videos that do, but I only intend to show the one that has the interaction.
Sounds good. And you're aware of that, what video she's referring to. I just don't want to get into a circumstance where the video is being played and there's something in that portion that you or your client may object to.
No, I think it's fair game to show the video of the alleged incident, and I think Ms. Landy is not going to talk about anything after that point, so I'm sure she'll cut it off.
Okay, and we know, okay, I get you. I just want to make sure we know where it's cutting off.
I'd be happy to just show it to the defense counsel right now before we get started.
Okay, why don't we do that?
It'll just take a moment.
Okay.
And then we're not going to talk about cell extraction. It's my plan. There was communication between the victim and a witness later about how the victim had to go to the hospital to get treatment because he felt he'd been injured. So that may be the only thing after the assault that gets spoken about, not the cell extraction itself.
So, but that conversation occurred between Mr. Bloom and somebody?
No, Your Honor. It occurred between the victim. It is likely not going to be admissible due to a hearsay issue. However, if it comes up later that did you make anyone aware of your injuries? Yes, I told so and so.
Got it. So it's a conversation that the victim has with someone else.
Correct.
Okay.
It may be a thing. I'm just saying I don't want to make it seem that nothing after the assault will come into evidence when it's possible that this conversation and the happenings of the victim receiving medical care may come in, and those did happen after the assault.
And just so that I'm clear, and I just want to be clear on this because of this, that you're initially not trying to enter that, but there may be something that happens that causes that to be entered.
I intend to enter the fact that he received medical care.
Right.
And got his medical records. I do not intend to have the two jail employees discuss that event. It just may be something that comes up in the course of cross-examination.
Got it.
This is going on super ultra speed.
But again, with that, if there is some dispute as to whether or not, and again, I don't know.
Well, there's over that point.
So I just showed Mr. Bernstein the entire 10-minute portion of it.
You just showed him that 10-minute portion in like 3 seconds.
All right, you're not going to have an objection to the admissibility of that document. That you're
Congratulations, it's all good.
No, Your Honor. Unless Ms. Landy really drops the ball.
All right. Yes. Okay. Anything else?
My witnesses are sequestered,
Got it.
except for my officer in charge of Eric, so he was staying at the table with me.
Got it.
JM,
the defense, Your Honor.
We weren't affected as badly as anyone
2
else.
minutes and then we'll be in and do this.
Okay, we're going to skip through a break. Judge's 2 minutes is closer to 15 minutes sometimes. Oops.
All right. What's the name district court in the county of Washington, state of Michigan, and now
you may be seated. All set. I think we can bring Mr. Blue.
Thank you.
Court does call the case of the people of the state of Michigan versus Jeffrey Wayne Bloom. Counsel, state your appearances, please.
Good morning, Your Honor. Counsel Ayden, the people.
Good morning, Your Honor. Sam Bernstein on behalf of Mr. Bloom is present to my right.
All right. And date and time set for the jury trial. Are the parties ready to proceed?
People are ready to proceed, Your Honor.
Yes, Your Honor.
All right. Let's bring the jury.
You will bring the jury.
If you will bring the jury.
Okay, so the defendant, this is what we know. He's in custody. It's a little tiny fly. It's like a fruit fly. It's buzzing around. Tiny. He's in custody, so he's dressed in street clothes here. They're not going to talk about the fact he's in custody. Is that one of the public defenders there on the back row? I think that's all the public defender's office sitting there in court watching. Defendant's already a talker. This is going to be good. This was the one we missed when we were following another court. It was from a week ago. Very rare. Yeah, we don't get to see a lot of jury trials from Judge Simpson. So this is a treat. Does he still teach at the university?
Did you see it? Your Honor.
Thank you. Court does call the case of the people of the state of Michigan versus Jeffrey Bloom. Counsel, state your appearance for the record. Thank you.
Good morning, Your Honor. Sam Bernstein with on behalf of Mr. Bloom, who's present with me.
All right, thank you. Members of the jury, you have been chosen to decide a criminal charge made by the state of Michigan against one of your fellow citizens. I will now ask you to stand and swear to perform your duty to try this case justly and to reach a true verdict. If your religious beliefs do not permit you to take an oath, you may instead affirm to try this case justly and to reach a true verdict. If each of you would please rise. You would raise your right hand. Do each of you solemnly swear or affirm that in the action now before this court, you will justly decide the question submitted to you, that unless and until you are discharged by the court from further deliberation, you will render a true verdict, and that you will render your verdict only on the evidence introduced and in accordance with the instructions of this court. So help you God. I do. You may be seated. You will soon receive a written copy of the instructions I am going to read to you, or will receive them. You may refer to them during the trial if we provide you a copy of those. Since
he's reading. Okay, here we go. We're going to jump straight to opening statements, which is the first we're going to hear about what this case is all about.
Bring the opinions of the other jurors who may have different backgrounds and perspectives. Slandi, opening statement.
Thank you, Your Honor. Good morning, members of the jury. We're here today, and I intend to produce evidence to show you that on May 30th of 2023, so last year, the defendant, Jeffrey Bloom, while being incarcerated at the Washtenaw County Jail, requested medical attention. He made it known that he felt he needed to have a medical professional come and evaluate him. Officer Navin, he asked Rocky Isley, a nurse, to come and look at this person. When Rocky came to evaluate the defendant, the evidence will show that Rocky deemed it necessary to check his vital signs. As a nurse, Rocky then touched the defendant's arm and took his blood pressure with a blood pressure cuff. I believe the evidence will then show that the defendant ripped his arm through that food slot while Rocky Isley was still holding on to it, slamming Rocky Isley into the metal cell door. I believe the evidence will then show that Rocky went to get medical attention later that day. The evidence I also believe will show that Rocky worked overnight. So he didn't get to go to the doctor until the 31st, but this did happen on May the 30th.
Because his work didn't let him go? What?
At the end of the evidence, I will be asking you to return a verdict of guilty of assault and battery for the defendant. Thank you.
Thank you. Mr. Bernstein, would you like to give an opening statement now, reserve, or waive?
He put his arm through the food
Very
slot
good. Proceed.
to get the blood pressure measured and then pulled it through, and the guy holding on the arm on the other side got yanked into the door.
Being in jail the way Jeff was is stressful, it's difficult, it's rough. And where Jeff was staying specifically in the jail was more difficult than normal jail. He was isolated, he was by himself, couldn't interact with other people, he couldn't leave but for an hour a day. And when he left, it was in handcuffs, he couldn't shower. Often he wasn't able to shower 4 or 5 days at a time, and this took a toll on him physically, with his skin, with his hairs, getting skin lesions. It's not easy time. And this wears on you day after day, week after week. He was doing 7 months in that situation. And it gets to you, physically, it gets to you mentally. Being told on this day that he couldn't come out and shower, that you don't get to shower today, continues to eat at Jeff. And just the inability to do basic human things is wearing at him. He's complaining of chest pains, and Rocky Isley shows up to evaluate him, and Jeff says, "I don't want you here." Tell him he doesn't want him there to evaluate him. Doesn't trust him, and Rocky has to convince him to let him take the vitals, okay? The situation, all this time, the agitation, the distress, the health problems, the mental anguish, it comes to a head in this encounter with Rocky. And following that encounter, decisions get made. Decisions to turn this into something that it's not, and those decisions have very real consequences for Jeff.
Can we approach?
Come in.
Decisions get made? What decisions? Decisions have consequences, and decisions were made. I rest my case. That's interesting. Interesting open. Both short, which is good. Outlaw Tiger, OG, congratulations. It's going to be 4 years clean. That is awesome. Decisions to charge him, apparently, were, with the real consequences being more jail time. Carler, welcome. We are live. This is a case we missed while we were following the previous stuff last week. If you've ever been depressed and gone 4 to 5 days without bathing and never assaulted someone, please raise your hand. I've been camping for that long, and by the end of the week, man, you were quite ripe. You're doing some background. Of course, we dive and swim in the lakes and stuff, which are frigid. At least where I did camping, it was. Been seeing that Carly Gregg, teenager charged with shooting her mom and shooting at her stepdad, is filing for a new trial. That was quick. He allegedly assaulted. Okay, Alex, here's what I got. The defendant, he's in jail right now. We can skip these breaks, by the way, because we're on replay. The defendant is in jail. He was in solitary and was somebody had told him he needed to get his vital signs checked. And so they checked his arm using blood pressure cuff or something like that, or feeling for a pulse or something. But he had to stand at the door and stick his arm through the food slot, which is, where they put the food tray. It's not huge, but it's big enough you can stick your arm through. So he sticks his arm through there. The nurse is on the outside, like holding his arm and measuring it. And the inmate on the inside yanks his arm back in. Doesn't grab the guy, but yanks his arm back in with enough force that the nurse who is holding onto the arm gets slammed into the door. So it sounds like the nurse was really hanging onto the arm. Gets slammed into the cell door, and the nurse went and got medical treatment at the hospital after his shift was over, all through the night. So it's an assault on an inmate, or it's an inmate assault on a jailer is what we're looking at. So we're going to have some testimony here in just a second. There we go. We're back. Why is it doing this? Pause. It was the 23rd, right? We're trying to play the 23rd or the 24th? I've gone and lost it. I'm sorry. We'll go back and fix it. It was on the 23rd. I had the wrong one. 23 was this one right there. I think that's the recording that's messing up. Speed is normal. Everything's fine.
Sir, please come forward and be sworn.
Here's our first witness.
See, raise your right hand. You solemnly swear to affirm the testimony you're about to give with the truth, whole truth, and nothing but the truth, God. State and spell your first and last name for the record, please.
Nicholas Maven, NICHOLAS NAVIN.
You may inquire.
Sir, how are you employed?
I'm employed through Washington County Sheriff's Office.
And how were you employed in May of 2023? And a corrections officer, where does that mean you work?
I work in Washington County.
Do you recall the date of May the 30th, 2023?
I do.
Did you have direct contact with anybody in the Washtenaw County Jail who's currently in this courtroom on that date? Who was that?
Mr. Jeffrey Bloom.
Could you please identify him by an article of clothing he's wearing and where he's seated?
Yes, he is seated over here with a white shirt.
Your Honor, may the record reflect the witness identify the defendant?
That objection, record shall so reflect.
Where were you assigned to work that day?
I was assigned to work the afternoon shift in the A max ops area of the jail.
The A max, what was the last word?
A max ops observation.
And what is that area?
So it houses several different inmates. It can be for disciplinary issues, detox. They have housing for maximum security inmates, suicide precaution inmates, and also protected custody inmates.
How many inmates to a cell in this area?
So in the A block area, it's one man cell, as well as the max area, and the observation area can hold up to 4 inmates per cell.
What type of cell was the defendant in on that day?
So the defendant was in one max cell, which is the max area, which is a single person cell.
Do you recall what shift you were working on that day?
Yes, I was working the afternoon shift, which is 3 in the afternoon until 11 o'clock at night.
Did you have any interactions with the defendant during that day?
I did.
What were your interactions like towards the beginning of your shift?
The beginning of the shift was just immediately met with agitation from the previous shift, disrespect.
Did you know why the defendant was irritated?
I had to do something with the previous officer in the previous shift. I'm not 100% sure, but I was told that.
I'm going to check, Your Honor. I think the answer to what I was told would be hearsay.
Well, he can give his understanding, to the extent that it revolves around his understanding of why. That goes to his state of mind. Objections overruled. Continue.
What was your understanding?
So my understanding that on the previous shift, Mr. Bloom was being very agitated and disrespectful to the officer on shift. And Mr. Bloom was given the option for his outside that day in the morning, which per our captain, level 1 inmates, which Mr. Bloom was at the time, were to come out first thing in the morning. And during my time, I worked from 3 to 11.
Did the defendant tell you that he wanted to come out during your shift?
He did.
And what did you say?
I told him due to his previous actions and due to the order given from our captain that he was unable to.
Did you have other interactions with the defendant during your shift on that day?
I had a few passing moments, yes.
What are some of the duties that you are responsible for when you're working in that part of the jail?
So that part of the jail, my biggest thing is keeping up on my wellness checks. I do it mostly about every 15 minutes.
What's a wellness check?
It's walking cell to cell to make sure everyone there is accounted for, breathing, healthy, and not under any duress, and to address any needs that the inmate must do.
Did the defendant indicate any needs to you?
He indicated at around 10 o'clock that he would experience chest pains.
What did you do?
I immediately radioed to our medical staff on staff and advised on the situation.
At that time, did the jail have in-house medical staff? What happened after you radioed to medical staff when the defendant told you he was having chest pains?
So shortly after, Nurse Rodney came down to the unit to evaluate Mr. Bloom. And as soon as I reached the food slot to the cell door, Mr. Bloom immediately stopped his arm and was screaming expletives and saying he was in fear for his life.
Now, not everyone may be familiar with what a food slot looks like in a jail cell and frankly, what this jail cell looks like. Can you describe how these jail cells look? Do they have bars? Do they have something else?
Sure. So the cell is comprised, the outside cell is comprised of a door which has to be reached by either our central control or a key. And the cell is a single room with a sink and toilet and mirror.
You say breached, is there opened basically? Okay. Now the door, is there anything besides the door on the front of the cell?
There is a food spot that you keep it open to pass food, however, the food spot. It can food, medications, or anything else that needs to be handled through the door without actually breaching the door.
Where is it located on the door relative to the ground? How high up?
I'd say it's about thigh high, I'd say.
So when Nurse Rocky arrived and you opened the food slot, you said the defendant stuck his arm out?
Correct. He stuck I believe it was his left arm outside the slot and was refusing to let Rocky do a medical evaluation. he was screaming and could not even breathe.
What happened next?
So that's when I asked him multiple times to, if he would like to have his vitals checked, which he did not respond to because I'm screaming. So then I decided to terminate the interaction and continue to pass medication through A block. So after that, I decided to go back again and check to see if he would vitals checked.
Did he?
He did. I went to his door and he started screaming again that he was in fear for his life when he went up at an officer. And in order to de-escalate the situation, that's when I used my radio to call for an additional officer, which ended up being Officer Tweedell, to stand by during the evaluation.
Once Officer Tweedell arrived, did anyone else come?
No, the only ones that were in the situation were myself, Officer Tweedell, and Nurse Rocky.
What happened next?
So once Officer Tweedell arrived on scene, Mr. Bloom kept on screaming and could not get a word in. That's when Officer Tweedell was able to reason with him to let Rocky do the evaluation through the food slot so we can get things going. And that's when Mr. Bloom complied to have his arm through the food slot and have the blood pressure put on his arms.
Why not go into the cell to do the evaluation with Nurse Rocky?
So Mr. Bloom was highly agitated, and as stated before, Mr. Bloom, it was a level 1 inmate. A level 1 inmate, when the door is breached, they have to have handcuffs and leg irons placed on. Due to Mr. Bloom's level of anger at the time, my duty sergeant, Sergeant Greg, I was informed to do the evaluation through the food slot.
Now, once Officer Tweedell, it's Officer, right? Officer Tweedell? Thank you. Once Officer Tweedell was able to speak to the defendant and start the evaluation, what happened next?
So once we were able to finally get the blood pressure cuff on him, that's when Mr. Bloom swiftly pulled his arm back into the food slot, back into the cell, taking the blood pressure cuff with him.
Did you see that happen?
I did. I tried to retrieve it back, but was unable to.
Did you see what happened with Rocky specifically, Nurse Rocky?
I was not, my attention was mostly on Mr. Bloom. My attention was not on Nurse Rocky.
When you're at the door, is there anywhere to look inside of the cell besides an open food slot?
So the cell door itself is opaque, but there are transparent windows if I would angle myself to them.
And where were you paying attention when this happened?
I was mostly looking towards the food slot with Mr. Bloom's arm outside of the food slot and just trying to make sure that everything he didn't try to.
Are you aware if there are cameras in the jail? Are you aware if there was a video recorded that showed part of this incident? Have you reviewed that video today?
Yes, I have.
Your Honor, may I approach the witness?
You may.
Mr. Navin, I'm going to be approaching you with what's been marked as People's Proposed Exhibit 1. What do you recognize that to be?
This is a CD or DVD.
And what does it have on it?
Bloom videos, also a red sticker saying People Exhibit 1, as well as my initials and Officer Tweedell's initials.
Is that a video? Is that a disc that contains the video from this incident?
Yes, it is.
Is it a fair and accurate copy of the video?
Yes, it is.
And I move for the admission of People's Proposed Exhibit 1.
Any objection or what here?
I have no objection, Your Honor.
Exhibit 1 is admitted.
Permission to approach to the jury?
Yes.
Permission to approach the witness?
Yes.
Are we going to be able to see this one?
apologize. I cannot make this window any bigger when it comes up, Your Honor. So there's a limitation of the system.
Sounds like a good band name, like a ska punk band name. Limitation of the System.
It should be coming up on the screen whenever it is switched over.
Hey, we get to see it.
Officer Navin, are you able to see that video on the screen that's sort of at your stand?
Yes.
Can you please tell the jury, I have my pointer here, if you are able to see that moving on the screen. This door here in the middle of the video, what's that?
That is the cell door for cell 3 MX in the max area.
And which cell was the defendant in, if you recall?
1 MX, which is more towards the upper.
Now I'm using my pointer to sort of indicate over here. Is that correct?
Correct.
For the record, this is a 10-minute video. I don't think there's any objection from defense counsel if I skip ahead just a little bit.
No objection.
Fast
All right,
forward
very good.
just a bit. Who's that on the video that we see now, that person?
That's all.
What is that thing that we see at the door?
That is Mr. Arm outside making stuff.
Or comments about the vacation?
I'm sorry. Sorry, my phone cut out. Say that again.
This is Gary. I'm the accounts director. I did pull up your full account. Do you have any questions about the vacation?
No, I was telling him that he said I bought a trip. I took the trip already.
I understand. Well, let me tell you what I have on my portal, okay? I have a Mr. Dwayne Boyne. I also have where it says after your name, more than 2,000 travel credits. How did you acquire them? You either went on a timeshare tour, paid into it, or had some dealings with Wyndham, Westgate, RCI, Marriott, or the Hilton.
I bought a lot of them on eBay. Is where I usually get mine.
Well, okay, but I'm letting you know what I have in my portal. See if it lines up. You let me know, okay? And then at the time that you first acquired your travel credits, your address was 5179 South, 1150 West in Ogden, Utah. That's what I have. And then it says, because of your travel credits and then dash, I'm able to give you 4 round-trip airfares instead of 2. And then 8 days anywhere in the world with all of your hotel paid for. You have an 8-day cruise to the Caribbean, 5 days in Vegas, and 5 days in Orlando. Your vacation does have a value of more than $6,000 that you will never pay, and 4 people can go. Matter of fact, the only thing that you would pay would be the booking amounts, which are $299 for Traveler 1, $299 Traveler 2, and that's it. That would cover the 4 round-trip airfares, all of your hotel paid for worldwide, the 8-day cruise, Vegas and Orlando. Everything you're receiving is confirmed through the email and also your Utah address. Do you have any questions or any comments?
Just send me the email. We should be good.
Well, do understand that occurs in verifications as well. and the amount total is $598, and we could secure that on either a Visa or MasterCard. What card do you want to use?
Whichever one you got, that would be great. Thank you.
Okay, we will use the Visa card. And when does the card expire?
I do not have it with me, like right now.
Okay, I can hold while you grab it.
Let me, can you hold on for just a minute? Let me
Yes.
look around. Hey, where's my wallet? Have you seen my wallet? Hold on just 1 second.
Okay.
Hey, do you know where the wallet is? Do you guys take EBT cards?
Do we take EBT cards?
Yeah.
Okay. As in food cards, food
Yeah.
credits,
Mm-hmm.
cards?
I get these on eBay as well. Oh, he hung up on me. He hung up. No. Okay. I have my wallet right there, by the way. Okay, sorry. We got sidetracked a little bit. That call came in. I missed the first part. It looked like it was a legitimate call, so I took it off the air. But good times. Okay, we're back. We're back to watching. I think this is going to be footage of the incident with the inmate. Oh, wait. Hang on. Pause for a second. I tried to take it. Somebody tried to call me, but it hung up. Okay, we'll go back to watching.
Officer, as far as you're aware, is there audio recording with these cameras?
We're not seeing anything happen.
22:30, I'm going to fast forward again just a bit.
She's holding down fast forward, so it's showing that we're not missing pertinent moments. Waiting for some people to suddenly appear in the hallway here. I told the first caller, oh, I think there's somebody there. I told the first caller, the guy that talked to me first, because that was the closer that I had on the phone when I brought you guys on. I told him that I'd already
At
taken the trip.
22:24:06, a person comes into view. Who's that?
Officer Tudell.
And who's the other person?
And that's me.
Who's that third person we see now?
That is Nurse Rocky.
Okay, it's really small on the screen. It's also pouring rain outside. Not excited about that. Got 3 people standing outside a door, leaning on the door. Looks like they're talking to the person on the inside. Looks like his arm is coming out through the food slot right now. Now the camera is blocking the view, or the officers are blocking the view. He is on trial for hurting the nurse. This is really poor video. I mean, you could probably have an inmate escape on camera and not be found guilty. This video is that bad. And away they go. Can we fast forward again?
Pause here, Your Honor, at 22:27 is, 2 seconds. Officer Navin, was that the incident that you had described to us a few moments ago, captured on video?
Yes, it was.
May I have a moment, Your Honor?
Yes, you may.
That was the incident? They just about bonked heads there.
I'll pass the witness, Your Honor.
Yeah. Cross-examination.
Your Honor.
Go get him, defense attorney.
So you went to the cell and you asked Jeff if Rocky could take his vitals, right?
Correct.
And you talked about you had to ask him several times.
Correct.
And he was screaming uncontrollably.
Correct.
I think you said he was agitated.
Correct.
Yeah. But you still tried to get him to agree to let Rocky take his vitals, right?
Correct.
And I think there was eventually, I guess, an agreement to get another officer that would be available to be there. So you saw the video, you're right up close to the cell. And Jeff.
Yes.
Yes.
Thank you.
Jeff's arm is out the food slot.
Yes.
Rocky is like right in front of you.
Yes.
Officer Tweedell is on the other side of Rocky.
Yes.
You guys are really close together.
Correct.
Maybe like a foot, 2 feet away from each other. Okay. You did not see Jeff grab Rocky.
Correct.
Right? That was not something that was a part of this. Jeff did not grab Rocky.
I did not see Mr. Bloom grab Rocky, no.
You did not see Rocky's body hit the cell door.
I did not.
So that was also part of this interaction, was you did not see Rocky's body hit the cell door, right? We watched the video from a camera angle. There's more than one camera in that hallway, right?
I believe so, yes.
There's a camera that points right at Jeff's cell door.
I believe so, yes.
And that would have been in the upper left-hand portion of the hallway, like if I'm looking at the video.
Correct.
We don't have that video here today, right?
Right.
We only have the video that you showed.
Right.
You would agree with me that the video right in front of that door would have been helpful for us.
Correct.
In the video that we watched, that video did not show Jeff pulling his arm back.
Correct.
That video did not show Rocky being pulled.
Correct.
And again, you did not see Jeff grab Rocky or Rocky touch the door, right?
Correct.
Okay. Thank you, officer.
Wow.
Can you redirect?
That was some good defense work. The officer basically said I was right there. And
are you
I didn't
allowed
see it
to
in front of me.
ignore a medical emergency or any potential medical emergency for?
No, every medical emergency, whether it be true or untrue, or just take it very seriously.
Why?
Just in case that actually something is happening. You can't respond to one thing and not respond to another thing, they can choose.
How fast did this happen?
The full incident took, I'd say about 20 minutes, 15, 20 minutes.
Let me ask a better question. How fast did it happen when the defendant pulled his arm back in the cell and you shut the door? Less than a second?
Yeah, I'd say maybe a second, less than a second.
Officer, in the video we watched, would you agree that you're sort of blocking the view of the camera to look at Jeff and Rocky touching each other, interacting?
I would say Officer Tweedale is mostly covering that portion up.
I apologize, Officer Tweedale.
Yep, Officer Tweedale is definitely covering that portion. That would be, that would have a food slot in the camera, yes.
May I have a moment, Your Honor?
You may.
Thanks.
Witness shows up in an Under Armour polo. It's interesting. Might be his uniform polo.
Thank you, Your Honor. Nothing further.
Yes, you may step down, sir. This witness may be excused unless there's an objection.
No objection, Your Honor. Thank you.
All right, thank you. Thank you, sir. You may call your next witness.
I would say for the most
Oh,
part,
Rocky Isley.
that witness was a witness for the defense. Rocky comes in his wheelchair from the injuries he sustained in this incident, which nobody around him saw, even though they were looking right there. That seems crazy. I mean, I don't doubt that there was something that happened, but for the officer to be watching his arm and not see this happen like a foot in front of him, that's pretty wild.
Please come forward and be sworn. Go ahead.
Before you take a seat, raise your right hand. I'll do solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So you got. Let's see, state and spell your first name.
Rocky R. Isley, R-O-C-K-Y, last name Isley, I-S-E-L-Y.
You may inquire.
Good afternoon, Mr. Isley. How are you employed in May of 2023?
I'm with a correctional orders in the jail.
What jail is that?
The Washington.
Where is that located?
Downstairs in this building.
Do you know the address for the jail?
2201 Hallback Road.
What township is that in?
Washington County.
Washington County. What state?
Michigan.
Thank you. And how long had you been working in the jail at the time of this incident in May of 2023?
I started in August of 2021.
So a year and some.
Now, on May 30th of 2023, did you have direct contact with someone in the jail who's currently in this courtroom?
I did.
Who's that?
Mr. Bloom.
Do you recognize the person you know to be Mr. Bloom in the courtroom?
I do.
Can you please tell me what he's wearing and where he's sitting?
He says that the defendant's stable. He's wearing a white shirt.
Your Honor, may the record reflect the witness identify the defendant?
That objection, record shall so reflect.
Now, what happened where you came to interact with the defendant on May 30th of 2023?
I was the night nurse on that day. I was currently out doing my evening medication pass. I believe I was on C block in the front of the jail. I was responsible for passing meds in the front of the jail. While on that block, they came across the radio that there was an emergency response to A block. So I responded to A block.
Were you the only nurse working that night?
There was 2 nurses.
But you were the one who needed to respond?
Yes, I was the closest, and that was the front part of the jail where A block is located is my responsibility.
What happened when you got to A block?
The officer, within A block, that officer is also responsible for 2 smaller sections, which is considered max and ops. They're just smaller little blocks. And he informed me that Mr. Bloom, that was housed in max, was complaining of chest pains.
How long have you been a nurse?
Since December of 2009.
And you are an LPN or an RN?
I'm an LPN.
When someone is complaining of chest pain, you as a nurse, what is the first couple of things, the first thing that you want to do?
Well, initially you do a visual assessment, and then I would, automatically I would want to take his vital signs, him or her vital signs.
Now, when you do a visual assessment, were you able to do that while the cell door remained closed?
I was.
Through where? How were you able to do it?
There's a window right there next to the cell door.
After you completed your visual assessment, what happened next?
I was going to take his vital signs, but the officer, Mr. Bloom, was agitated when he saw me arrive and did not want me to be the one to assess it. So he was already agitated in front of the window.
Did he say anything to you?
Not directly to me. He was just stating that he didn't want me to assess him. He didn't trust me. Other, disparaging type things.
Did he have a reason not to trust you?
I have no idea why he would have a reason to not trust me.
So as you came closer to the cell, or as you were standing there, what happened next?
The officer then made the decision, because of his level of agitation, that he was going to call another officer there just to stand by so they could open the cell door and I could take his vital signs and assess this.
Now, when you say open the cell door, can you be more specific about what was opened or how this medical evaluation was going to take place?
Well, from my understanding, his custody level, and because of his level of agitation, they would actually have to physically open the door so I could go into the cell and assess it.
Is that what happened?
That is not what happened.
What happened?
By the time the second officer had arrived, the officer that actually was on that block made the determination that it probably would not be safe to open the door, even with there being 2 nurses there. So they requested that I take his vital signs through what they call a food slot or a bean slot.
A bean slot?
Yeah, it's a small, it's the door, it's about thigh level that slides down, and that's where they pass their food trays and things through.
Now, you said a moment ago there were 2 nurses present. Is that correct? Or I want to make sure I understand your testimony.
I was the only nurse, but there's 2 officers.
Oh, 2 officers.
Another officer to stand by.
Very good. Thank you. So that was the determination to happen through the food slot. What happened next?
So that was the only way that I was going to be able to get his vital signs. So he put his arm through the slot, and like I said, it's about thigh level. So I had to kind of crouch down a little bit, put the blood pressure cuff on, and put the stethoscope on, and have to look at the gauge. And so as I was pumping up the blood pressure cuff to get his blood pressure, he suddenly just jerked his arm inside the back inside the bean slot. While I had the cuff on, it's a slot that's about that
So you're using your hands to demonstrate a distance? To me, that looks like.
The bean slot's about that wide. So when his arm was through there, I put the cup on. I had my right arm underneath, kind of supporting his arm while I was pumping up the blood pressure cuff.
Why would you do that? Why would you put your arm underneath his arm to support it?
Just for comfort and so the cuff, to get a proper reading, I can cup my hand like this. If it was just laying flat on the bottom of the slot, you know, I would probably get an accurate blood pressure reading from it. So supporting his arm like this, and when he pulled his arm in, you know, my hand was actually underneath the blood pressure cuff. So the force of that coming back into his cell kind of jerked me forward. And I was on an angle because I was looking at the gauge. So when that happened, my arm went into the slot with him, and I jerked forward, and the side of my head hit his subboard.
How fast did that happen?
Just in a few seconds.
Okay. When this was going on and you were taking his vital signs, I'm sure many people have been to the doctor, if not everybody, or the nurse or something. What are the vital signs that you're going to take to evaluate if somebody's chest pains might be a medical emergency?
Just if his blood pressure was, you know, dangerously elevated, you know, I hadn't even got the chance to take his pulse or anything like that. Now, based on the blood pressure and if I had gotten his pulse on, you know, his O2 and his heart rate, then, you know, that would have directed me more towards, you know, if I actually had the request from the officers, maybe that, you know, whatever their policy is, to probably get more officers or whatever we need to do, so I could have actually physically gone in and assessed him, you know, get the stethoscope, get heart sounds, things like that.
So when you came to the door and you were performing your medical evaluation and it came time for you to touch the defendant to perform the blood pressure check, did you consent to touching him in that way to do a medical evaluation?
Did I consent?
Yeah. Did you feel good about making contact with him? You felt you consented to that?
Yeah.
And he consented to your touch to him?
Put his arm on the slot. I was putting the blood pressure cuff on. He was, you know, complaining of chest pain, so.
And he agreed to let you do that?
Yes.
Did you agree to have your arms pulled inside the cell and be slammed into the cell door?
I did not.
Now, after that happened, we're not going to talk about a bunch, but did you ever seek medical care?
When it initially happened, nobody asked me if I was all right. I wasn't, you know, I was jarred by it.
And only talking about what happened to you, how did you feel later?
Approximately an hour after it happened, you know, I started feeling that I had a kink in the side of my neck. So I reported that to the duty sergeant, and he then, I guess, contacted the lieutenant, and they then informed me that the jail wanted me to go and be evaluated at the hospital.
Did you do that?
I did.
Which hospital did you go to?
St. Joe's, Trinity Health.
Yeah, everybody keeps calling it St. Joe's. It was St. Joe's, now Trinity Health, is that correct?
That's right.
Did you get a copy of your medical records and give them over to law enforcement in my office for this case?
I didn't personally get them. I believe that they were requested.
Sent over, released?
Yes, released.
Yeah.
I mean, I did release them.
Yeah.
But
And did you have a chance to review those medical records this morning?
I did.
And understanding there may be some other things in them, did you have a chance to look at them and see that they were the ones from this case? Your Honor, may I approach with People's Proposed Exhibit 2? And I have a copy for defense as well.
Your Honor, I have no objection.
To the admission of Exhibit 2.
Yes, Your Honor.
Exhibit 2 is admitted.
Thank you. Mr. Isley, I just want to talk about a few things. I believe you communicated there were a couple of inaccuracies in these records. I wanted to talk about those. Which parts did you notice that were inaccurate on the first part?
It says that I work in a prison, actually in jail. And then it says it said prison bars, like instead of the bean spot, so it wasn't prison bars.
Okay. But as far as your vital signs, as you recall, your symptoms, everything else in here was accurate?
Yeah.
Did you receive any radiology tests?
No.
Did you have an x-ray?
I believe they did get an x-ray.
If I can direct your attention to page 3. Medical decision-making. Does that indicate that you may have had an x-ray on that date? And what does it say?
That was negative for a fracture or other acute abnormality.
And what were you, what was sort of the decision that the physicians made about your medical status at the time of this evaluation?
That it was like a strain, I strained the muscle in my neck.
All right. May I have a moment, Your Honor?
You may.
She really takes the moment. Where is that?
I have no further questions. May I approach the witness to retrieve Exhibit 2 and publish it to the jury?
Yes, you may.
I will pass the witness at this time, Your Honor.
Cross-examination.
Your Honor. Mr. Isley, before we get into the meat of it, I want to acknowledge some things about your job. So you work in the jail here, right?
That's correct.
That's like one of your main duties, or that is your main duty?
As a nurse, yes.
Okay. And I'm guessing working in a jail isn't the easiest medical job that you could have gotten, right?
That's correct.
Not some cozy urgent care where people come in with like poison ivy and stuff like that.
I'll be very good.
There's a different specific population there, right?
Yes.
People might be agitated when you see them. Is that fair to say sometimes?
Okay.
You could meet people that are difficult to deal with, right?
Yes.
Sometimes, I'm not talking about Jeff, but there could be people with like mental challenges, things like that.
Yes.
Okay, and so you're radioed to go see Jeff on a complaint of chest pains.
Right.
And you, of course, go to see him. Jeff is, well, I don't want to say an older gentleman, but he was like 57 at the time.
I mean, I don't know what his age is, but that's...
Okay. Well, I guess someone being closer around 60, you might pay more attention if they're complaining of chest pains.
Oh, I don't determine their age. I mean, I treat saying chest pain is chest pain.
No, I'm not saying that you need to determine their age. I just meant, would you be more concerned if someone's complaining of chest pains and they're, older than a 23-year-old?
Not really necessarily. I mean, I treat chest pain, there's young people that, that have chest pains also. I mean, that's not for me to determine.
Jeff is agitated when you get there?
Yes.
He's yelling when you get there?
Yes.
He doesn't want you to see him, at least at first. He has to be convinced to see you.
Well, I told him that, that I was the nurse that responded. I mean, I'm here. You're complaining of chest pains. If it's truly chest pains, and I'm here to evaluate while I'm the nurse.
Sure. And so there was a request that there be a second officer with you?
Yes, so the first officer requested that another officer respond.
When someone's agitated like that, could they have higher blood pressure?
Definitely. I mean, their agitation raises the blood pressure.
Okay. And someone like yelling and screaming, that could be a high blood pressure situation?
Yes.
You make the determination to take Jeff's blood pressure, right?
Yes.
And you wrap the blood pressure cuff around his arm.
Right.
And after wrapping the blood pressure cuff, you then touch his arm, right?
I put this hand underneath the cuff, cupped it. So when I inflated it, it wasn't sitting flat on the bottom of the bean slot. Which, to put pressure on it to deflate it so I wouldn't get an accurate blood pressure.
And your fingers touched his skin?
My hand was cupping the cuff that was already on his arm.
Okay. So your hand is touching the cuff that's around his arm?
Right.
Okay. And he's sticking his arm out a food slot.
Right.
And this is thigh high off of the ground. So, okay, so he's like bent over to get his arm out.
Correct. And so am I.
So are you. And so what he's like this. It's like kind of an awkward position.
Correct.
Okay. So he's got an awkward position, sticking his arm out, and then you are touching the blood pressure cuff that's around his arm, right?
Right.
And that's when his arm pulls back?
Yeah,
Just pulls his arm back?
Pulls his arm back.
Okay.
I am totally against violence against nurses, but this
you
seems
left the
like
jail, you
a
went to the
bit of an
doctor's
overreach.
office. Right.
Sorry, can you repeat that?
After, later on, you went to a doctor the next day?
No.
The next morning or something?
No, I'm still at work. This happened, right in the middle of that, so it was probably 9 o'clock or so. So.
At night?
Yes, I work on night shift from 6 at night until 6 in the morning. So about an hour after the incident is when I felt that aching tightness in my neck. I reported that to the duty sergeant. And then, within a half an hour, he had communicated with the lieutenant.
Who's the lieutenant?
I believe it was Lieutenant Arnett.
Okay.
Who was in charge of
So Lieutenant Arnett told that person to tell you to go to the doctors?
that I needed to go to the hospital and be evaluated.
But at the time that Jeff pulls his arm back, you're not like in pain, you're not noticing anything that's a problem, right?
I mean, not in my head. Yeah, it hurt, but I still had pretty much my entire shift left to complete.
And so you need to finish your duties in the jail, so you keep going on, right? Okay. When you go to the doctors, you talk to a doctor there, right?
Well, at the hospital, yes.
When you go to the hospital, you talk to a doctor there, right?
Correct.
You tell a doctor that an inmate grabbed your arm and pulled back?
I told him that I was assaulted at the jail.
Would it help refresh your memory to look at the medical records to see what the doctor wrote down?
Sure.
Judge, could I approach?
You may.
Okay, I just said I'm all against nurses, violence against nurses, but this seems like a little.
Just let me know when you're done reading. I'll fetch it from you.
It's an overreach. He lost his balance and banged his head. He's just testified that there was no contact skin to skin. So, I mean, the inmate pulled his arm back while the pressure cuff was being inflated with no contact skin to skin.
Okay, yeah.
Okay, I'm just gonna snatch that.
I'm not sure how you can call that assault.
So you would agree with me that what you said to the doctor, an inmate grabbed his arm and pulled back, right?
Yes.
But that's not your testimony today. I mean, what you said happened was that Jeff pulls his arm back with the blood pressure cuff on it, right? Well,
an objection.
I was going to be forming the question because there wasn't a question.
Okay, got it. Okay, that's fine.
Isn't it true that you testified earlier that Jeff pulls his arm back with the blood pressure cuff on it?
Yes.
Your testimony here is not that Jeff grabbed your arm, but it's that he pulls his arm back with the blood pressure cuff on it. That's what your testimony is?
That he grabbed my arm?
Your testimony on the stand, right? And, you know, what you're telling officers and stuff is that Jeff pulls his arm back with the blood pressure cuff on it.
Yes.
Okay. I have no more questions. Thank you, Your Honor. Thank you, Mr. President.
You redirect.
Mr. Honor. Nurse Isley, did you write this document?
No.
Your medical records? Somebody else wrote it, right? Did you in fact write an email documenting what happened?
I did.
And would reviewing that email
Everyone's reading the email now.
would that refresh your recollection? Is that email something you wrote at the time that this happened?
Yes, ma'am.
And Your Honor, I'm going to approach with something I don't intend to do as an exhibit.
You don't intend it to be?
Unless defense counsel will stipulate that this is in fact a copy of the email that was written.
That's not a proper exhibit.
Okay.
Well, whose email is it?
It's the victim's. It's his statement about what happened. I'm going to ask him to review it as a writing that he made at the time of this incident, documenting what happened on that day.
To refresh his recollection?
To rehabilitate him after the attack on his credibility.
I understand your rationale.
Yes.
And you want to admit that as an exhibit?
She's not sure.
Yes, Your Honor.
And your objection to the exhibit is what?
Yes, Your Honor, I'm going to object to it. He's here to testify. He's given a narrative several times. He can use it to refresh his recollection, I would say. But beyond that, I mean, this is something that shouldn't be published to a jury. I mean, he could.
Well, but counsel, you were the one that opened the door to it, or through the questioning opened the door to it by indicating that he made, or at least trying to say that he made a contradictory statement to medical personnel.
That's fair. I guess he did make a contradictory statement.
Well, I don't know whether he did or not. You're saying that he did. And so the people ought to be able to rehabilitate him if that's through an email that he wrote contemporaneous with the events, then I'm going to let that happen.
Thank you, Your Honor.
So Exhibit 3 is admitted.
Thank you. Aaron, may I approach with Pickles Exhibit 3?
Yes, you may.
And I'll make a clean copy for the jury to disregard what's on the back in a few moments, but I'll approach with this now. Mr. Isley, do you recognize that to be the text of the email that you sent to the sergeant on May 31st, 2023 after this happened?
Yes.
Okay. Direct your attention down, halfway down About halfway down on that, there's a sentence that starts, I, parenthesis, Rocky R. Isley, LPN, and parenthesis, applied the blood pressure cuff. Do you see that sentence?
Yes, ma'am.
And can you please read that sentence in its entirety for the jury?
I, Rocky R. Isley, LPN, applied the blood pressure cuff, and while beginning to inflate the blood pressure cuff and supporting his left arm with my hand, Mr. Bloom forcefully pulled his arm and blood pressure cuff back into his cell. Due to the quickness and forcefulness of this action, the right side of my head, shoulder, and neck hit his cell door.
Thank you. May I have a moment, Your Honor?
You may.
Wow, they get to read that? That's interesting. Okay, so this guy sounds like he's a piece
Nothing
of work,
further
the
in-
defendant.
Thank you.
Direct, Your Honor.
There's a reason he's in maximum security solitary confinement.
So when did you write this email, Mr. Isley?
The day after the happened.
Okay. And did you write this before you went to the doctor's office?
Before I went to the hospital, no.
You wrote this after the hospital?
Yes.
Yeah. So we discussed earlier that when you went to the hospital, there were statements about an inmate grabbing your arm, right?
I'm going to object again.
Sustained. Sustained.
You spoke with a doctor at the hospital, right? And you made statements to that doctor.
Yes.
And you reviewed those statements here in court today.
Yes.
And we have an email that we just reviewed, right?
Yes.
And that email does not say that an inmate grabbed your arm.
I don't know.
So you'd agree with me that this email is different than what's on your medical records?
Object again.
Sustained.
I have no more questions. Thank you.
Is there any further things with this meeting? Excuse?
So you may step down. Thank you. Any objection to the excusing this witness?
Oh, I have none, Your Honor.
All right.
The
very
judge
good.
is guzzling
We're going to
coffee.
take a brief recess. Can you take the jury? You have another witness?
I do have one more, Your Honor.
All right. Let's take the jury.
All right, for the jury.
What's the recess for? Probably because the judge has been guzzling coffee.
I think with that voice, they'll get it right. You may be seated. All right. What I will do is, why don't we take about a 15-minute break, come shortly after 1.
We're going to
Let me try to take care of some other matters I have to take care of. Let me ask this. Any objections to the introductory jury instructions as given?
No, Your Honor.
The only thing, Your Honor, I don't mind them taking notes. I don't know if that's like a court-specific thing, but I wouldn't mind if they wanted to take notes, that's all. Because the court indicated that the court would.
I would not let them take.
Yeah, wouldn't think it was necessary.
And I think that's within the court's discretion to do.
I agree. I do think it's within the court's discretion and the court gets to choose. So I have no objection.
Oh, well, I'm not arguing what's within the court. I'm saying I don't mind personally if they want to take notes. That's all.
And if I decided that in my decision, I would have asked, but thank you. All right. He can go back and court's going to stand in recess.
If I want your opinion,
Why
I'll
don't
give
we
it
say
to you.
10 after?
If I want your opinion, I'll give it to you, says the judge. Wow. Okay, so we'll give just a few minutes here. This case, the defendant, the gentleman who was in all white next to the young defense attorney, he's an inmate at the jail. He said or conveyed that he was having some sort of medical condition, medical situation. And so the jailers brought a nurse to his jail cell because he's in solitary and at a risk as well. They treated him through the door. They basically said, well, we've got to measure your blood pressure. So we'll use the cuff through the door. So if they were going to open the door and go see if there was a problem, like see him, he would have to be cuffed and in chains because that's just a security procedure. Instead, they just treat him through the food slot. So he has to like bend over and stick his arm through the food slot. In doing this, put the blood pressure cuff on. He yanks his arm back. The nurse who was trying to take the blood pressure reading, because the arm was pulled back, it either pulls him because he's holding onto it, or pulls, or causes him to lose balance, and he hits his head, neck, shoulder area on the door, causes him some neck pain. He goes to the hospital and gets treated. It sounds like this defendant is a real piece of work, just a joy to be around, and might have other issues to deal with. Let's see here. Give me 1 second. I thought we were back, but apparently we're not. There we go.
Court County, Washington, State of Michigan, now back in session. The Honorable Judge J. Simpson preside.
You may be seated.
All right.
All right, can we bring him?
I think the judge thinks this trial is a waste of time and resources, but at the same time has respect for the fact that it's allotted by law, constitutional. Waiting for Mr. Bloom to be brought out. There we go.
Does recall the case, People State of Michigan versus Wayne Bloom. Counsel, state your fear. All right. We ready to continue?
Witness takes the stand. Or at least gets called. Spelling it correctly gives you an A+. Yes. I didn't even want to try to pronounce it, BG. Sphygmomanometers? Manometers?
May be seated. Your Honor, the jury is present.
Thank you. Sunday, you may continue.
Thank you. The people called Tyler Tweedle.
Meters. That was my second guess.
Sir, please come forward and be sworn.
Sphig or Sphog? Sphogmoman.
Please raise your right hand. You solemnly swear testimony about to give will be the truth, the whole truth, and nothing but the truth, so we got.
Gentlemen dressed all in black.
State, spell your first and last name for the record.
Tyler Tweedale, Tyler, Tweedale, Twdale.
You may inquire.
This is the other.
Good afternoon,
Corrections
officer.
officer.
How are you currently employed?
Sheriff's Office.
And were you employed in that capacity in May of 2023?
Yes,
ma'am. And we've heard a little bit about, were you involved in an incident with the defendant on that date?
Yes, I was.
Who's that person to you?
Mr. Judge.
Do you see the person you know to be Jeffrey Bloom in the courtroom? Can you tell me where he is sitting and what he is wearing, please? Your Honor, may the record reflect and identify the defendant?
Without objection, record shall so reflect.
How did you come to be at Mr. Bloom's cell that evening?
The officer, Nicholas name, the primary officer, I was working C unit, and officer name called for another officer to stand by for a medical emergency. So I assisted with stepping down.
And when you arrived, what did you do?
So I kind of briefed the situation, circles, this exaggerated, just kind of, stuff like that. I was doing my kind of report from the doctor, and he said he was having a medical emergency heart attack. So I kind of got him to follow on with the process to be evaluated by medical staff.
And to be evaluated by medical staff, what does that include?
So usually we open the slide door to be evaluated by medical staff, blood stocks, everything like that. However, with this level 1 status, we had to do a spot.
And what otherwise how would you choose to do it if not on a level 1 status?
So we'll just stand by one officer, pop the door open, breach it, have them sit down on the bed, medical staff will assess something, go from there.
What medical staff was present for this?
Medical staff Rocky.
And do you know Nurse Rocky?
Yes.
Have you worked with him before this night? And when he was there and after you had called Mr. Bloom down, what happened?
Mr. Bloom agreed to stick his arm through the boot slot and to be assessed by Rocky. I stood by on the side of it, and as Rocky was putting the blood pressure cuff on, Mr. Bloom pulled his hand back. I had my hand hovering above the boot slot. He was kind of agitated, so I put my hand on top of the slot. I was able to treat the blood pressure pump and hose when he pulled it.
So why would you do that with somebody? You said he was agitated, so I did this. What is that link? What is the causal connection between those two things for you?
Just never, with the boot slot open, the medical staff touching them. I want to just have my hand there in case he tried anything that I could have seen. And I just want to make sure my hand was there in case anything happened. So I just kept it over.
When that happened and he pulled his arm in, what did you do? Or I think you said a little bit about it already, but what did you do in that moment?
I grabbed tried grabbing the whole blood pressure cuff and tried pulling it back out. I was only retrieving the hose and the pump of it. And after that, I didn't reach out to the slot and don't try to be sorry.
All right. Now, when you are discussing where you were standing, can you describe a little bit for the jury where you were standing relative to the cell as best you recall?
Yeah. So it was, the cell was 1 max. I was far in the hall. Door was here. Food slot was here. I was standing on the right side of the door. I was right above the seat. Slot my back like to the hallway. So,
Officer Tweedle, I'm going to show you what's been marked and admitted as People's Exhibit 1. Here in just a second. Now, after after Mr. Bloom pulled his arm in and the door was shut, were you able to still observe him inside of his cell?
Yes, it was.
What was he doing?
He was swinging the blood pressure cuff that he still had around and just yelling at us, making us not to come to the cell.
Is the judge glaring at the inmate? The defendant? Buffering.
Do I have permission to publish Exhibit 1 to the jury?
Without objection, yes.
I keep forgetting this is not long enough to go all the way.
You're once again blaming the technology and not the operator.
Indeed, Your Honor.
Okay, go ahead.
I'm sure it is operator error.
Why is the defendant mouthing? He's getting really lippy.
It should be ready to go whenever the court is ready. Officer Tweedle, do you see the video on your screen?
Yes, I do.
Can you describe if you see yourself in this video?
Yes, I do. Right closest.
Are we looking at the sort of the back of your body in your right arm? Who's standing to your left?
What's that wrong?
We're going to watch this terrible video. I still haven't heard why we don't have the video that was literally right above this door. This was the best angle we have? Or this is the only angle we have?
Hey.
The first.
It's the judge. Please answer, Judge. Please answer.
I'm not even sure why. I don't even like that person. I guess I shouldn't have said that out loud. What'd you say?
Can we get a name for the record?
Can we get a name for the record?
I'm comforted it can't
wasn't
possibly,
you.
it can't possibly be either of us.
Yeah. So, my apologies for the interruption.
Officer Tweedle, can you tell us where you're positioning your arms and your body at this time in the video? It's about the 22, 25, and 52 second mark.
Yeah, so I'm standing a little farther away. We're told not to stick our face or anything close down there. So right now I have my hand above the food slot, stepping a little back. And I think we're talking.
And now where are you?
I position myself closer to the door, closer to the food slot, just so my hand could be closer to it.
This is the moment. This is the incident.
And what's happening now?
We shut the food slot, exit the cell, that's when you notify the duty sergeant on the back.
Were you able to observe Rocky's arm being pulled into the food slot?
Oh, no, I didn't see it.
What were you paying attention to at that time?
I was more paying attention to his arm.
Who's his?
I'm sorry, Mr. Bloom's arm, focus on the blood pressure cuff, and that was my attention on.
Did this happen? How quickly did this happen?
Very few seconds, so I'd say 3 seconds or so.
Can I have a moment?
You may.
So neither officer saw this happen, even though they were standing on literally on both sides of the victim. It's a solid door with a bean slot. Yes, that's what we've heard.
Officer Tweedle, you spoke a little bit about what the defendant did after the food door had been shut. Do you recall that testimony? How would you describe the defendant's behavior?
He was very agitated and aggressive by swinging the blood pressure cuff and threatening us not to come to the cell.
How was he swinging the blood pressure cuff?
He was just like a
fan dancer.
So you just made a motion with your body that I want to document for the record. So I'll describe what I think I saw. You tell me if you agree with it. It almost looks sort of as though you were lassoing. You had your arm rotating in a circular motion.
Yes. Lasso's good.
Okay, thank you. I'll pass the witness, Your Honor.
Cross-examination.
Like a lasso.
Sure. Officer, so you were getting Jeff medical attention that day because he stated he felt like he was having a heart attack? And at first, it seemed like he was going to refuse medical attention, right?
Correct.
I think the word agitation has been thrown out a lot.
Like a washer?
He wasn't as, calm as he's sitting here today in front of you. Is that right?
Correct.
And you testified that you had like a rapport with Jeff so that you were able to talk with him.
Correct.
And that rapport helped you just kind of like take the temperature down for a moment. And so that the blood pressure cuff was able to be placed on.
Yes.
We saw the video. You guys, you're standing there with Officer Navin and Rocky, you're really close with both of them physically?
Yes.
Probably like a foot from Rocky, maybe like 2 feet from Officer Navin. You spoke about, well, you did not see Nurse Rocky's hands on the blood pressure cuff, right?
I saw him place it on there, but I did not physically see his hands on it.
So you saw Rocky place it on him, but as far as after that, you did not see his hands on the blood pressure cuff when Jeff pulls his arm back, right?
I do not recall. I just kind of focused on the blood pressure.
Right, you had talked about your hand was hovering over it. And you spoke about being able to grab the hose and the bulb.
Yes.
Even though this all happened pretty fast, you were able to retrieve that as Jeff's arm was going back?
Correct.
You also did not witness Rocky's body hit the cell door, right?
Correct.
We watched the video. You weren't here, but we watched it earlier. That video is from like a side angle of the cell.
Yes.
There's also another camera in that hallway that looks more directly at Jeff's cell.
Yeah, at the end of the hall, I believe where there's a big window, there's a camera in the top right here facing it from where we looked at it.
That would give us a much better view of what we're talking about, right?
Yes, I don't know what's operation. Yeah.
You don't know?
I only videos are.
Well, did you check? Okay. I mean, there's an investigation of an alleged crime here. Did anyone check that video?
Objection, speculation.
Well, did Officer did you check that video?
Objection, asked and answered.
Sustained.
Do you have any personal knowledge of anyone checking if there was other video?
No, I was not at the review the video. It's usually starts as well.
So your superiors would have access to whether that video is working? And the video that we have, you don't really see a whole lot of the video, right? I mean, look, it's fair to say that we don't see it happening in the video.
Yes,
we don't see Jeff pulling his arm back. We don't see what's going on. Thank you.
Judge is busy signing paperwork, bench warrants.
You may step down, sir. Any objection?
No, Your Honor.
This witness is excused. Thank you, sir.
Scared of people rest.
All right. May we then take the jury, please?
Take the jury out. This is going fast. State just rested. Jury is headed out the door.
May be seated. Are there going to be any witnesses for the defense?
I was hoping the court would indulge me a couple of moments to speak with Mr. Bloom about that call.
All right, very good. Then we'll take him back. And how much time do you think you need?
Would the court indulge me at least like 10 minutes?
All right, well, why don't we do it this way? We'll take him back and then we'll reconvene at 2:00.
Thank you so much.
Thank you for the being recess.
Okay, so they're going to go back. Have a little talkie-talkie. Decide if he wants to testify. And skip it too far ahead.
The District Court for County of Washington, State of Michigan is now back in session.
You may be seated. Let's get him out.
Progress.
So Amber called me on the phone to tell me how to say that big blood pressure cuff word. There's a reason we all call it a blood pressure cuff, because that other word is impossible to say. Who's singing the Little Bunny Foo-Foo story? Song Chef? Lego? When it's just this part of the word, Bob, is it manometer or manometer? You're the bunny with the ears. Got these. Got my ears on. Do we need to zoom past this part, or is it? I thought we were bringing the jury, the defendant. Okay, here he's. There you go.
Or is it your determination or your decision?
Hang on.
All right. Are there going to be any witnesses for the defense?
I'm not going to call any witnesses, Your Honor.
All right. Mr. Bloom, you understand that you have an absolute and constitutional right to testify?
Yes, sir.
You understand that that decision as to whether or not you testify or not is your decision to be made in consultation with your attorney. You understand that? Is that a yes?
Sure.
And you also have had an adequate opportunity, you believe, to discuss that, as to discuss whether or not you should testify with your attorney.
Yes.
And taking all of that into consideration, sir, is it your determination or your decision that you do not wish to testify in this matter?
Yes, sir.
Thank you. All right. Counsel, then after, when the jury comes out, after the defense rests, then we'll go right into closings if the parties are prepared to do so.
Yes, Your Honor.
Yes, Your Honor.
All right. And then I would presume to then give instructions there immediately thereafter. And I'll go through them by number and then ask you whether or not you wish any additional instruction. Court's intending on giving 3.1, 3.2, 2.4 regarding the elements of the charge along with the elements. 3.3, the defendant not testifying. 3.5, evidence. 3.6, witnesses' credibility. 3.10, in terms of time and place. 3.13, possible penalty. 3.15, exhibits. 3.16, written instructions in the jury room. 4.1, I think is appropriate, although there are not, those are statements as evidence against, defendant statements as evidence against defendant. There were certain statements that were made that could be viewed as the defendant's statement as evidence against him. 4.3, circumstantial evidence. I don't think there was any impeachment. There was actually prior consistent statements, but 4.5 I don't think is appropriate under these circumstances. I did not take judicial notice of it. 4.6. It was either party requesting 4.9.
I have requested it.
You, any objection to 4.9? Motive?
I think she can request it and get to them. I don't know that it's necessary.
I think that given the defense counsel's opening statement, motive is a question that's properly, I think the motive jury instruction would be properly before the jury to explain that motive need not be proven by the people.
Intent, 4.16. I will give the motive instruction. 4.16, intent. 5.2. Well, actually, 5.2 would not be appropriate because there's not conflicting evidence. 5.3. 5.11 is a bit more problematic from the court standpoint. These are technically not police witnesses. However, they are law enforcement. So.
And it's my understanding they're not sworn law enforcement officers.
Correct.
They're corrections officers. But I do believe I would request 5.11 just for the sake of, because they do work in corrections, that distinction may be somewhat less important to a person who's not constantly involved with police and understanding the distinctions between those different departments.
I agree with that reason, Your Honor. That would be my request.
All right. I would only change that I would make to the standard instruction is I would be using the term correctional officers as opposed to police officers, unless there's an objection to that.
No, thank you.
17.2, just battery, then definite. So 17.2, 17.14, 1.5, 17.16, then 13.11, and then one more, just 13.14. Those are all the ones that the court has, without any additional ones that were requested by any of the parties.
13.12 or 13.11?
What I said, you mean?
Yes.
I said 13.11, jury deliberations at verdict.
And then the last one that you said was?
Was 13.14, or 3.14, I'm sorry.
3.14, those are the two that I highlighted on my list. Okay. Thank you, Your Honor.
So wait, 3.11, Your Honor?
3.11.
Okay.
And then 3.14. I'm sorry, I was saying those numbers.
13.11.
Yeah, no, I did say 13.11. You're right. All right.
Those sound good to you, people, Your Honor.
All right. Good. I think what I'll do is I'm going to move. Just so that we have it all correctly. Did not testify.
Dwayne, if I can ever get to receive my gifted or my promised cruise that I can bring you with. Congratulations on 21 months.
More sense. And counsel. Looks, but I'll do it this way. Show you the proposed verdict form. I'm going to ask whether or not you have any objection to the verdict form.
I think we're about ready to skip ahead through this.
Thank you.
Any objection from the people? Any objection from the defense?
No, Your Honor.
All right, thank you.
What's the defendant doing? Putting his finger up in the air. Defendant isn't happy about how the case has gone so far. Well, maybe you should have been a lawyer.
Exhibit. Oh, go ahead. I'm sorry.
Was there like something on the back of one of them?
I made a clean copy of Exhibit 3 during a break, Your Honor. So now it only contains the front and there is no back.
Awesome, thank you.
And I have a copy of the Exhibit 3
packet.
The disc contains 3 videos. We only watched the first one. So if the jury wants to watch it back, there's proprietary video technology. So we'll probably have to come back in the court and play it again. It's only the first video on that disc.
Could I ask, Ms. Lundy, was that email, was that published already to the jury?
No.
It was not because of the back copy.
Okay.
Okay.
Jill and Brian.
Sure.
People are ready.
Mr. Brinson.
Oh, yes, Your Honor.
All right.
I often tell the crank callers that tell me I want a cruise that I want to take a cruise up in Jackson Hole on the Snake River, and ask if Carnival or some Norwegian or somebody will cruise the Snake River for us, knowing that the Snake River is not big enough for any of those boats. Although you can float it. It's a big river. It's a big river, but it's not a cruise river. We had half of a phone call just this morning. There was a good one last week. That was pretty fun. Sarah Boone starts next week. Whitewater cruising needs to be a thing. Legally Blonde, I got the Boone bingo card.
Thank you. People having rested, any witnesses for the defense?
No, Your Honor, thank you.
All right, very good. Parties prepared for closing argument?
People prepared.
You may proceed.
May I move the question?
Depends on where you want to put it, but yes, you may go. That's all right. That's
Thank you.
Okay, let's keep an eye on this defendant and see what he has up his sleeve here. There's a jury here. This is a jury trial.
Good afternoon. When we started this morning, I let everyone know what I expected the evidence would show. Started talking about that Rocky Isley was a nurse working in the jail, and on that date, the defendant was incarcerated in the jail. Talked about how we were going to hear from different witnesses about the defendant reporting to experience a medical emergency. We heard from 3 different witnesses. First, from Officer Naveen, talked about how that was his assignment that day. And the defendant had been upset that day. He talked about how he was upset even earlier in the day. He understood that the defendant was upset about something that had happened before Officer Naveen had even gotten there that day. We heard that he cannot ignore anyone's request for a medical emergency. Because Officer Naveen, Officer Tweedale, and Nurse Rocky Isley have a responsibility to make sure that the people in the jail are safe. That's their job. The corrections officers are there to make sure that the folks who are in the jail are okay. They don't make the decisions about who goes there. They don't make the decisions about who leaves. Their responsibility is safety. Officer Naveen is talking about how he checks every 15 minutes, make sure the people that are in his cell block are okay. He talks about how he makes sure Mr. Bloom is okay. Nurse Rocky tells you about how it's his responsibility when someone says they're experiencing a medical emergency. He doesn't care how old they are. He doesn't think something's more or less likely based on their age. He doesn't think something's more or less likely based on who they are. He is there to make sure they are okay. Officer Tweedale is the one who speaks to the defendant and says to him and gets him to calm down enough to be medically evaluated. Why? Because it's his job. That's his job. He's got to find a way to communicate with each person to help them. Nurse Rocky, I'm sure everyone has experienced a nurse who made you feel safe, who made you feel cared for and listened to. And Officer Tweedale, when this is going to go down and he knows that Mr. Bloom has been upset and he knows that Mr. Bloom has been agitated. He told you how he levels his hand above the food slot door just in case. Why would you do that? Just in case. Safe. But the only person out of these 4 men who didn't care about the safety of another person was the defendant. You're going to get jury instructions in a few minutes that display for you and educate you that the law does not allow sympathy nor prejudice to influence when you are making this decision. You should not be prejudiced against the defendant because he was incarcerated, nor should you be sympathetic to him because he was incarcerated. The law requires an examination of the facts, and the facts are simple. The facts are the defendant was in the jail in Washtenaw County. The facts are that the defendant said he was having a medical emergency. The facts are that earlier in that day, he'd been very upset he was not allowed to get out of his cell. The facts are that he was a level 1 security. The facts are that he had to be medically evaluated through his food slot. And the facts are that when he was being medically evaluated, he yanked his arm back in that food slot, and that slammed Rocky Isley into his wall, or into his door, rather. Now, I can't tell you what defense argument there might be, but I will tell you that you've seen a video, not my favorite angle. You've seen medical records.
Hang on, you have another angle that we haven't
And
seen?
you've got a copy of Rocky Isley's own statement that he made on May 31, the day after this happened in the night, about what happened.
Judge is eyeing the defendant pretty closely.
Everyone has a right to be safe at work. Everyone has a right to be safe at homes. All of the witnesses that you've heard from today helped to keep the defendant safe at his home. His home he didn't choose. He didn't choose to be in the jail, but that's where he was. Each of those men told you how they made a choice to keep him safe, despite his behavior, despite his...
Andy, stop for a moment.
I'm sorry.
I apologize. Take the jury, please.
I'm so sorry, Your Honor.
No, it's not you. It's not you. Take the jury, please.
She's like, should I have not have called the jail his home? I know that was a bit of a stretch. Very few
Ms.
people
Lundy,
say, just like home.
Everybody may be seated. And I apologize for interrupting you in the middle of closing.
I'm terribly...
The behavior from him, from Mr. Bloom, I am not going to have in terms of his gestures, his noise, and everything, particularly behind Ms. Lundy's back. Not going to have it. Mr. Burnton, I'm going to give you a chance to talk to your client about it and tell him that he is to sit there quietly or not at all before I continue. Okay. Take him back. Court is standing in recess.
All right.
Well, there goes another company benefit. You can't talk behind the prosecutor's back. All right. I'm going to just do well, this is playing here. We're going to keep that playing. I'm going to just do a quick check. It's still loud.
That's all right. Yeah.
Hot mic.
Good call. No, good. Are you sure I have so many? They're good. They're lovely. I can't say no.
Go back on the replay and see what happened.
Yeah. Yeah. Okay.
Okay, we're going to pause that. We're going to go to this. We're going to replay really quickly. If I can put replay on the screen. Where's replay? DSK2. Nope, on there. Replay. We're going to watch the defendant here, just above me, top left. Do we have audio?
How they made a choice to keep him safe, despite his behavior.
Okay, that was it. Hang on.
He
goes, let me turn the volume off because it's to keep him safe despite his behavior. He goes, just that little pop, mouth open. He gets like a third of a second, And look at Judge Cedric Simpson's eyes. They're on him. And immediately he's like, boom, out. Okay, so we'll watch that in real time. See if there's anything before then. Leading up to this. This is...
Each of those men told you how they made a choice to keep him safe, despite his behavior, despite his...
Lundy, stop for a moment.
I'm sorry,
I apologize. Take the jury, please.
I'm so sorry, Your Honor.
No, it's not you. It's not you.
Apologize
Take the jury,
twice.
please.
Badge the door. Jury's out. Or jury's leaving. She thinks she
Ms.
did
Lundy,
something wrong.
everybody may be seated. And I apologize for interrupting you in the middle of closing.
I'm terribly...
The behavior from Mr. Bloom, I am not going to have in terms of his gestures, his noise, and everything, particularly behind Ms. Lundy's back.
Okay, so we're gonna rewind further. There's got to be some more. There's got to be some more to this. Let's watch her closing. Oh, there's some. Let's see. Start with her closing right here. Okay, so playing along right here. She's talking. He's just looking around a lot. Little tilt of the head. Boo-doo-doo-doo-doo-doo. He's not buying it very much. Couple gestures. There's a mouth. There's something. Nom nom. I think he says nom nom here. Let's listen to see what he said.
About what happened. And I said, day after this happened in the night. About what happened.
Okay.
Everyone has a right to be safe at work. Everyone has a right to be safe at homes.
There was a big one right here. You got a gesture, hand up. Where's my right?
All of the witnesses that you've heard from today helps to keep the defendant safe at his home. His home didn't
choose. Okay.
Each of those men.
Yeah. So they sort of mouthed off a bit. Oh, guess what we have? We have a phone call. Hello? 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 Man, I so want a cruise. Hello? Hello? Call me back. I can't hear you. Okay, sorry. Nothing doing there. Okay, let's back up to where we were. Took a break.
You may be seated. And if we can bring Mr. Bloom up, please.
Judge has a headache. Mr. Bowen's back.
Court recalls the case of People versus Jeffrey Bloom.
Ashland people.
Good afternoon, Mayor Sam Bernstein with and on behalf of Mr. Bloom.
And as I've apprised counsel,
mute next to me.
during the course of the trial, Mr. Bloom, I don't know, and I'm going to assume that, at least for these purposes, that you weren't doing it intentionally. There have been comments which I could hear all the way up here, and I'm sure the jury could hear it during the course of these proceedings, that then when Ms. Lundy got up to give her closing argument, there were additional comments. I didn't do anything about that, but the moment the gyrations with your hands occurred behind her back, I stopped the proceeding. I'm not going to tolerate any of that. I will stop it again if that's what we have to do, but I'm going to admonish you and warn you at this time that the court is not going to allow that type of conduct to occur. With that admonition,
Bring the jury.
Mr. Bernstein.
I was going to say there were some times where Jeff was speaking with me during the trial.
Oh, I understand that, but there were other points at which there were just extraneous comments. So I was letting those go, but I'm not going to have that and have counsel interrupted during the course of their closing arguments. With that admonition, are the parties ready for the jury?
Your Honor, I also understand there's been information given to the jury that.
Correct. Yes, for the purposes of the record, I did inform counsel. So at no, that the jury did not take that in any way to be applicable either to Mr. Bloom or to the people, because I had stopped Ms. Lundy in the middle of her closing argument. And I had indicated that they are not to take any delay or interruption by the court. They are not to attribute it to either party. They are to attribute it to the court of its own doing, so that the jury understands that and does not hold that against the people or against the defendant.
Thank you, Your Honor. I am ready to proceed.
Is the defense ready?
I am ready, Your Honor.
All right, let's bring the jury.
He says, I am, not we are. I'm ready. My client has been sufficiently muzzled. Shan't talk anymore. Whoa.
What is going on? All right. Go ahead. Thank you.
What just happened?
Still hot mic.
Still hot mics. Mics are hot, waiting for the defense attorney is like, oh, don't look at me. I was assigned to this case. Where's your client?
Is he ready to what's pardon?
I don't think he wants.
Sick, Your Honor.
No.
No. Did you want to go back there and try to talk with him? Because in the record should reflect, if it doesn't already, that after the court's admonishment to the defendant and asking whether or not the people in defense were ready, that the defendant on his own accord decided that he would leave the courtroom. That the defendant, therefore, by transport, that it appears that he does not wish to come back out.
I really should try to speak with him, Your Honor. I mean,
yes, you should.
It's a significant right to be at your own, like in the Constitution or something.
One which one can, I believe, voluntarily forfeit.
That's fair too. Yeah.
So before we get to that stage, why don't I'll stand in recess and allow you to have an opportunity to chat with him. All right. Thank you.
All right.
So, like, starting right.
Here's the replay. So they say, are you guys ready? I love this prosecutor. He's just laid back, quite literally. They're like, are you guys ready? And he's like, wait, take me out. And he just gets up and walks out. the judge's face. He's like, what? Just what? Oh. Let's go full speed. He's like, look at the defense attorney. The three in the back, the public defenders in the back, they're just like, not my circus, not my monkey, and they're trying to just keep a straight face, right? And the defense attorney is like, Judge, I didn't know either. Let's see what happens. So they're talking. They're chilling. He's like, yeah. Oh, there he goes. There he goes. And he does not look. Did the judge see him walk out? Yeah, the judge saw him walked out. Okay, so let's skip this break again. And this is nuts. Okay, we get about another 10, 15-minute break. So many breaks. This should have been like a 3-minute court case. Where's the ending? Oh, it's right at the very end. Here we go. We're almost done. Okay.
Yeah, Alan's trying to put the jury out. So. All right. Okay, we're back on the record. Court does recall the case of the people of the state of Michigan versus Jeffrey Bloom. Counsel, state your appearances.
Ashley Lonnie for the people.
Sam Bernstein for Mr. Bloom, Your Honor.
All right. Mr. Bloom is not present. If I say anything incorrectly, please, counsel, correct me. Just prior to our last recess, when we were trying to continue with the trial, after the people had begun their closing argument, I stopped the proceedings, gave an admonishment, had the jury gave an admonishment to the defendant regarding comments that he was making, as well as gestures in terms of his hands because of the positioning of the podium behind the prosecutor's back. Gave him that admonishment, then told him that I would not tolerate any of that behavior. At that point, I did not hear anything, or at least nothing that was audible or understandable from the court in terms of the defendant saying anything. The defendant got up and he removed himself from the courtroom. Transport took him back. I took a recess in order to allow Mr. Bernstein to speak with his client. I was then informed during the course of that from Transport that Mr. Bloom did not wish to return to the courtroom. And so that's kind of where we were left. The question that arose as to whether or not this court, given the defendant's behavior, whether or not this court could continue with the trial, even though we just had closings and the verdict to go. Out of an abundance of caution, after speaking with counsel in the court, looking up for some guidance in this regard, the court did find me, I think it's Rule 43, I didn't bring my copy out of the federal rules, which specifically address the issue where a defendant removes himself from a trial in the middle of the proceedings or doesn't elect to participate. I did not see a rule specifically in the Michigan court rules governing that. As I did a brief research in trying to find cases, the case of the people of the state of Michigan versus Jerry Oliver Swan, that being 394 Mich 451, came to light
It was a 1975 case, so it's a little bit old, but it still looks to be good case law. I gave that to counsel, asked them to take a look, see if we could, between all of us, make a determination as to what would be the best way to proceed. And granted, I don't think anybody's had an opportunity to do any extensive research on it. However, I would indicate that if nothing else, the Swan case is illustrative of a point.
And illustrative?
The synopsis basically indicates the Supreme Court held the defendant did not reappear in the courtroom after a mid-trial recess, had not reappeared 4 days later, and testimony was received regarding attempts to locate him. Trial court properly proceeded with the trial with receiving, part of the testimony in the jury's verdict in the defendant's absence. Taking that without anything else in front of me as sort of a guideline, the court believes that the defendant has conducted himself in a fashion where he has made himself absent mid-trial. It seems to me that what the Swan case seems to point to is that an opportunity be given where this defendant being in custody, we don't have to locate him, but at least an opportunity to be given to the defendant to come back and voluntarily participate in his trial. Having said all of that, after speaking with counsel, the court has made a determination to adjourn the remainder of the jury trial. We are adjourning it to September 30th, 2024 at 10 a.m. For closing arguments and final instructions to the jury. During that week period in time, in essence, the court is giving an opportunity for the defendant to reconsider his decision. Also to allow his counsel to potentially have a conversation with the defendant as to what may be the implications of him having removed himself from the proceedings. But I think in fairness, and since they are monumental rights that the defendant would be forsaking in terms of leaving his trial,
I think you've made
the court thinks that it would be prudent for the court to do so. That was long, however. Either counsel have anything to add or to say contrary to what the court has indicated on the record?
Nothing contrary, Your Honor.
Neither for me, Your Honor.
All right. Very good. And I do appreciate both counsel being patient as the court was trying to wade through this and also participating in trying to find something that would guide us. It was really, truly appreciated on this court's behalf. So this matter is adjourned to September 30th, 2024, 10 a.m. for continuation of the jury trial. Thank you.
Thank you, Your Honor.
Well,
I should, don't go off yet.
Oh, sorry.
I should also know one other thing. The people had requested that I give to the jury an instruction to not talk to anybody, same instruction that I had given them during the opening statement, but just to reiterate that to them. And the initial thought was to bring them back out, give them that instruction, and then have them go. And I think it was correctly pointed out that Mr. Bloom not being present here may send some signal to the jury. I assured counsel after they had indicated that they trusted the court to give that instruction to the jury. I did do so. They each acknowledged that they understood that instruction before leaving. So
thank you, Your Honor. That's accurate. People wanted to be sure that they're going to understand that those not talking to people and all those risks do continue during this adjournment. I appreciate that. Thank you.
Yeah. Thank you, folks. I think that's it. 14A stands adjourned.
14A stands adjourned. All right. So while they are going about doing that, I think we've got, hang on one second, I'm trying to check my phone. The roofer guy says he's going to come today, which is just awesome. Let's see. So something's supposed to happen today, right? We've got an interpreter. It's going to be at the end of the day. Uzbek interpreter.
You are the only people here who can help Jeff.
Yeah, this is it. This is today. Let's back up.
An interim instruction and said, and just tell you that during the course of this trial, the defendant has chosen to no longer be present for these proceedings. Today. I would admonish you and ask you to remember that his absence should in no way impact your deliberations or your verdict. All right.
So it was last week to this week.
Point of closing arguments.
The 23rd to the 30th, 7-day extension.
When we stopped, you were in the middle. However, you may begin again with your closing argument.
Thank you, Your Honor. Your Honor, with the court's indulgence, at this time, I'm going to end my closing argument. I trust that the jury remembers it and remembers what I had to say, and I don't see the point in sort of rehashing all of it. They've been paying diligent attention. Okay. If that's okay, if that pleases the court and defense counsel.
That is fine with the court.
Thank you. I do reserve any further argument for rebuttal closing.
Thank you.
Thank you.
Mr. Bernstein, closing argument.
Thank you, everyone, for coming back. That day, Rocky saw Jeff in the jail and found Jeff to be yelling, saying he didn't trust him. And we've been through this trial now together, and we've seen how that has all played out. And my question for you guys is, where's the beef? Really, where is the beef?
That's a great
There was a question posed to Rocky. Did he have any reason not to trust you? Rocky said, not at all. There were no problems between Rocky and Jeff. There was no history between Rocky and Jeff. I don't mean to minimize any impact from this on Rocky. The prosecutor in her closing did a good job of talking about the emotional connections that we have with nurses. I get it. My wife's a nurse. My grandma was a nurse. That's not exactly the situation here, though. This wasn't the cozy urgent care. Rocky said when he met Jeff, Jeff is just screaming uncontrollably. He's in fear for his life. He doesn't trust him. There needs to be an officer to calm him down. It's just not a normal situation. And I can understand how Rocky feels the way that he does. After he leaves there at first, there's no problems. Nothing hurts. He walks away. Then he starts talking to people. He starts retelling the story. There's his email. There's his medical records. The story changes. It does. The situation that we do have here is that there are two officers standing right there. Both officers said that they did not see Rocky hit that door. They did not see Rocky hit that door. They did not see Jeff grab Rocky. We watched a video twice. That video showed nothing at all. Of course, there was one major way that we could have resolved this. There was a camera pointed right at Jeff's cell, and no one talked about doing anything to see if that camera captured it. Instead, we were shown a video that showed nothing. A Going back to my original question, guys. The original question I posed, where is the beef? And I don't mean motive. Okay, this isn't an Agatha Christie whodunit novel, right?
He's going for
but
all the
like,
quotes.
why? The question isn't whether Jeff pulled his arm back. The question is, why did he do it? If there is no intent to commit a battery, then there is no battery. Without intent to commit a battery, there is no crime. Without a beef here, there is no battery. We asked you here for your help, and I get how we got to this point. Jeff is not going to get the benefit of the doubt. He was in jail. That's fine. I get it. A lot of what's been talked about in this trial has always come with an explanation. It's been glossed over, minimized, explained away as if these things don't matter. Does it not matter that Officer Navin testified that he was standing right there and didn't see that happen? That he didn't see Rocky hit the door? Does it not matter that Officer Tweedell was standing right there as well and did not see Rocky hit the door? We saw a video twice that didn't even show anything. We didn't hear about any efforts of anyone trying to get the other video. I mean, does it not matter that Jeff is having an emergency? Does it not matter that there's a perfectly reasonable explanation for this? That's not a crime. The guy's freaking out and doesn't want Rocky to touch him. He's talking about he's in fear for his life. Jeff doesn't want to hurt the guy. He has no beef with the guy. He has no beef with Rocky. I say that these things do matter. Jeff does deserve the benefit of the doubt. And legally speaking, he gets that benefit of the doubt unless you are really shown something otherwise. But we have not seen that here. Absolutely not. You are the only people that can help Jeff. And we have asked you here to listen, and we are asking you now for that help.
Thank you, Mr. Bernstein. Rebuttal.
Defense counsel says you are the only people here who can help Jeff. But that's not true, because there were plenty of people who tried to help Jeff on the day that this happened. There were guards to get him the medical attention he wanted. A second guard brought in to make sure nothing happened. And Rocky brought in to assess his vitals and see if he needed emergency medical treatment. All three of those people tried to help Jeff on that day. All three of those people tried to get the defendant the help he needed to keep him safe, which is what I talked about last week. Safety is the priority of the three men that you heard from. That's their job. Defense counsel's asking, does it not matter that this guy is freaking out? Look at the law. Look at the jury instructions. Listen to the ones that you're about to hear and consider. Does the motive matter? No. And that his intent can come from all of the surrounding circumstances. And what does he do with that blood pressure cuff after he pulls it into that cell? Waves it around like a lasso. It's a game. It's a game for the defendant. Mr. Burnside says this video shows nothing at all, except that that's not the case, because the video shows you exactly what Officer Navin testified to, exactly what Officer Tweedale testified to, and it shows you Tweedale standing there, frankly, making a better door than a window, blocking the view of the camera. Those men easily could have come up here and said, yes, I saw the whole thing. I saw Rocky get slammed, but they don't, because that's not what happened. They're focused on Jeff. They're focused on the defendant. They're focused on this person who's demanding medical attention, and they're so concerned they do it through the food slot. Rocky told you how he had his arm, and he showed you by demonstrating he had his arm all the way out, bent all the way down. This isn't like somebody got grabbed by the hand and pulled in. This is somebody who's already extremely close to that door.
Hey, where's the beef?
The defendant's the only person that day who made a choice to compromise the safety of another human being. People are asking you to hold him accountable and convict him.
Thank you. Members of the jury, the evidence and arguments in this case are now finished, and I will now instruct you on the law. That is, I will explain to you the law that applies to this case. Remember, you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy or bias or prejudice influence your decision. You must avoid reaching conclusions that had not been, you must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about the case individually, but you should do so only after listening and considering the opinions of the other jurors, who may have different backgrounds and perspectives than yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all of the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each witness has said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, you are to follow what I say. At various times, I have given you some instructions about the law. You must take all of my instructions together as they are the law that you must follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of this case are. Apply the law as I give it to you, and in that way decide this case. A person accused of a crime is presumed to be innocent. This means you start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty, unless and until you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. During the course of this trial, the defendant chose to no longer be present for the proceedings. His absence should in no way impact your deliberations and verdict. Every defendant has an absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must affect your verdict. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses and anything else, and the exhibits that I've admitted into evidence, and anything else I may have told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe to you some things that are not evidence. The fact the defendant is charged with the crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that is supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should only consider these questions as they give meaning to the witness's answer. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to the case. However, if I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case solely from the evidence. Your decision should be based on all of the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I have said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you have based upon the witness's disability, race, national origin, ethnicity, gender identity, sexual orientation, religion, age, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and reflect carefully about the evidence. There are no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see and hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or other personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all of the other evidence in the case? Sometimes the testimony of different witnesses will not fully agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide this case. If so, you may choose to not accept anything that witness has said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. Prosecutor in this case must also prove beyond a reasonable doubt that the crime occurred on or about May 30th, 2023 within Washtenaw County. Possible penalty in this case should not influence your decision. If the defendant is found guilty, it is my duty as the judge to fix any penalty within the limits as provided by law. When you go to the jury room to deliberate, you may of course take your jury books with my full instructions. You also will have contained within that jury book at least one of the exhibits that have been admitted into the trial. As to the video, if you wish that was admitted, if you wish to see that, then you just need to request it. As I've indicated, when you go to jury room, you will be given a written copy of the instructions that you have just heard throughout this trial. And as you discuss the case, you should think about all of my instructions together, as they are the law that you are to follow. The prosecution has introduced evidence of a statement it claims the defendant made. Before you consider such an out-of-court statement against the defendant, you must find that the defendant actually made the statement as it was given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all of the other evidence in the case. You may consider the statement in deciding the facts of this case. Facts can be proved by direct evidence from a witness or exhibit. Direct evidence is evidence about what we actually see and hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining.
You went with the weather analogy.
You may consider circumstantial evidence. Circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence, can be used to prove the elements of a crime. In other words, you should consider all of the evidence that you believe. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find the person guilty of a crime. The prosecutor does not have to prove the defendant had a reason to commit the alleged crime. He only has to show that the defendant actually committed the crime and that he meant to do so. Defendant's intent may be proved by what he said, how he said it, and by any other facts and circumstance in evidence. Ladies and gentlemen, you have heard testimony from witnesses that are correctional officers. That testimony is to be judged by the same standard you use to evaluate the testimony of any other witness. The defendant in this case is charged with the crime of assault and/or assault and battery. The prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant committed a battery upon Rocky Isley. A battery is a forceful, violent, or offensive touching of a person or something closely connected with the person of another. The touching must have been intended by the defendant, that is, not accidental, and it must have been against Rocky Isley's will. It does not matter whether or not the touching caused an injury. Second, that the defendant intended either to commit a battery upon Rocky Isley or to make Rocky Isley reasonably fear an immediate battery. As used in these instructions, the words force or violence means the use of physical force against another person so as to harm or embarrass them. For a battery to occur, the touching must have been intended by the defendant. That is not accidental, and it must have been against the will of Rocky Isley. Does not matter, as I've indicated, whether or not the touching caused an injury. Ladies and gentlemen, when you go to the jury room, you will and have been provided a copy of my final instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everybody has a fair chance to be heard. During the deliberations, make sure to turn off any cell phones or the communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you discuss the case amongst yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty to talk to the other jurors and to make every reasonable effort to reach agreement. Express your opinions and the reasons for them. Keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you are wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because the other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. I have already given you instructions. Well, I'm gonna hang on one moment, folks.
We have an error.
If you have questions about the jury instructions before you begin deliberation or question about the instructions that arise during the deliberations, you may submit them in writing and give that to my bailiff.
I'm going to close out the poll.
If you want
72%
to
of us say he's
communicate with me
guilty.
while you are in the jury room, please have your foreperson write a note, give it to the bailiff. It is now not proper for you to talk directly with myself. You, of course, may not talk to the lawyers, the court officers, or other people involved in this case. Ladies and gentlemen, as you discuss this case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside of the jury room.
Anybody. John, thank you very much.
Now we will have our very sophisticated way of drawing one of you off as a juror. Ms. Hardwick.
Which one don't you like?
It's 1920s bingo. Go ahead.
Juror in seat number 1, juror number 5, juror in seat number 2, juror number 44, juror in seat number 3, juror number 49, juror in seat number 4, juror number 36.
There's 4.
Juror in seat number 5, juror number 27.
There's 5.
Juror in seat number 6, juror number 24, and
6.
juror in seat number 7, juror number 60.
There's 7 balls in the machine. She's turning the crank. Do, 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 do. Jeopardy music is playing in the courtroom. And the winner is...
Juror in seat number 6, juror number 24.
All right, that's you. You are excused. As I've explained, you are an alternate, so we have your phone number. So if something happens to one of the other jurors, we will call you back into service and you will enter deliberations. On behalf of a very grateful judge, thank you very much for your service to the court, and to our society, and serving on this jury, sir. You are excused. Hands got it. Mr. Allen, if you could come forward, please, sir. Please raise your right hand. Do you solemnly swear or affirm that to the utmost of your ability, you will keep these persons sworn as jurors in this trial in a private, convenient place where they will be undisturbed, and that you will not allow any communications orally or otherwise to be made to them, and that you will not communicate with them yourself, orally or otherwise, unless ordered by this court to do so, and that you will not communicate to anyone the state of their deliberations or their verdict until they have rendered same unto this court, so help you God.
I do.
All right, you may take the jury.
All rise for the jury.
Sorry, I have to run and talk to my wife about the roofer. I don't know if they come back right now. Hold on 1 second.
You may be seated. Any objection to the instructions as given by the court?
I have none, Your Honor.
All right, thank you. And on this matter, we will stand in recess on the Bloom matter until such time as we have a verdict and or questions or inquiry from the jury. Thank you.
You check out my email. Okay. Check out my email about the adjournment Thursday, please.
What did you say?
That's
Friday.
That's her back there, I think. Okay, are we ready then?
Are you ready?
I guess we are.
All right, let's do it. Court does call the case of the People versus Unique Hayward.
Absolutely.
Okay, we're now going to fast forward. This is today's trial, but we're going to see if we can fast forward to if the jury comes back. Let's see.
Was in place before, is continuing. Would I be incorrect in that assumption?
I would agree with that assumption.
All right, very good. Are the parties ready then to receive the verdict?
They are, and for the record, the people would be fine with Mr. Bernstein's assertion to the court about that, about his final to be present for the verdict. While, of course, the reading of the verdict is a critical stage of the trial, it has perhaps a different procedural effect that the others say in trusting Mr. Bernstein's assertions.
All right.
I'm likewise ready for the verdict, Your Honor.
All right.
We're bringing the jury in. There's the verdict. Do we need verdict music?
And that back to the floor person.
Juries do what juries do, and this jury has gone and done it. They have reached a verdict in a record time. I think it was about 15 seconds by our clock. We have a defendant accused of assaulting an officer in jail while getting a blood pressure reading. I tell you, everything I've read, this guy might be a bad apple. But I'm not sure if the evidence is presented is enough to convict in this case. So we're going to find out here in just moments as the judge has looked at it, handed it back to the jury. He either is going to tell him to go back and try harder or he's going to tell him to read it here. Yeah, not a stellar member of society here, but he might get away with this one. He's already caused disruptions throughout the trial. So we're going to turn this down here and listen.
Speaks for you. All right. And sir, you have reached a verdict. What is that verdict?
We have reached a verdict of not guilty.
All right.
Not guilty.
I'd like the jury poll.
No, Your Honor.
No, Your Honor.
All right, very good. Ladies and gentlemen, I want to thank you very much for your service. We will send you back. I'll be back to formally excuse you momentarily. I know this has been a weird kind of journey having to come back, but I do appreciate your patience in helping us get through this. All right, thank you. Mr. Allen, you may take the jury.
There was no beef. There was no beef. I think the compelling testimony was the officers saying, I was right there. I didn't see it happen. And then we watched the video twice, it not being on there. I think the jury...
matters or anything else?
No, Your Honor.
All righty. Thank you.
The jury did right. Plus, you've got the legal...
Teenage stands in recess.
You've got the stands in recess. Thank you, Judge. You've got the legal definition of what happened, and it required contact. And the victim himself said there was no contact, that he was never grabbed, and that and there was no skin-to-skin contact. So it's hard to prove that intent there, that he meant to do that. They need the other video. Maybe they can reach... No, they can't. That would be double jeopardy. They should have brought that other video, though. All right. The verdict timer, I didn't even have time to build it. Okay, our second roofer is coming. He's coming today. He's driving from what we call Little Washington. which is about, I don't know, half an hour away. And it's raining, and he's going to be getting up on our roof. So I think I need to go film him for insurance purposes in case he falls down. A twofer, yes. We're going to see if we can get the roof fixed here right away. All right, we're going to go to lunch, and I might take a brief nap. My head is not clear right now. Oh, my goodness. Donnie, you love the music. Love it, too. Are you saying we're done with us for the day? Not necessarily. I've got more work to do. We've got more work doing on the Sarah Boone stuff that I've been working on in the background. Live stream the roof. The roof is so bad. I would be embarrassed. The beef is not cooked. You must rebook. Thank you, Lacey. Just call it a day. I might. I make no promises at this point. Tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. Please stay safe till we go live again when we go live again. That's all I've got. I've got to go down to the basement, check out what happened with the flood down there now that it's all dried out. So roof and basement, and then maybe nap. So we'll see. You guys have yourselves a great day. Love you all. Be good to each other. I think that's it. Yeah. Peace out.
Is that correct?
I saw a chicken fight.
If they didn't, I would lose my mind.
Scratch all that. Oh, that was terrible. I apologize.